My lord, at page 11, if you, my lord, will see. My lord, here we have given the date of arrest. We have calculated, and it comes to 5 years, 1 month, and 15 days as on date, my lord. As on 29/9, that is today. And these are substantiated, my lord, by the paragraph of the charge sheet as well as order is also enclosed. If your lordship so desire, I can take your lordship from this.
What is the term, prison term for him?
10 years.
Under which?
Well, under section 20,
Section 20 of the UAPA.
UAP Act. And your lordship may take up my compilation is also there.
Yes. So at the trial is still going on.
No, the trial is over. He's convicted to undergo 10 years imprisonment. That's maximum. The others are 5 years and one is 2 years. He has already completed.
There's not a bail order. Appeal is not against a.
No, it's against conviction.
It's against conviction. And recently, my lord, the Supreme Court in one case, the judgment is delivered, my lord, Satyendra Kumar Antal. It is delivered on 11/7/2022. Says, my lord, that the principle of 386 may also be made applicable. 436A, if he has, and two decisions I have placed, my lord, where half of the sentence, the bail was granted during pendency of the appeal. Those two are annexed here,
Where? Which?
along with the petition. Two judgments. One, your lordship may see page 15. This is the Lalu Prasad Yadav's case, my lord. Paragraph 10, my lord, at page 21. Proceeding further on the facts, page 21, my lord.
Yes.
Proceeding further on the facts of the incident case, this court finds that it is not in dispute that appellant has completed more than half of custody, approximately 26 months, against the sentence of 3.5 years. Awarded in the incident case so and so. It is also true that court has been following uniformity matter of suspension of sentence of the appellant suffering conviction under so and so. Some of the order passed by this court have been referred to on behalf of the appellant and taken note of above. It is true that number of cases through this court following the same yardstick has allowed suspension of the sentence to the appellants, but they have not been released. That is, of course, particular. But he was released on the ground that he has undergone more than half of the sentence. Then next, my lord, is from a single judge of our High Court, page 23. Page 23. The relevant is page 24, third para. Without going in deep into the merit of the case, considering the fact that appellant has served out sentence of 5 years out of 10 years of imprisonment subject to final hearing connected appeal, it is provided that operation of the sentence passed in so and so, there was a POSCO case on so and so shall remain state. Till disposal of the connected appeals, the applicants are directed to be released on bail. So this is
Supreme Court judgment.
Supreme Court judgment, well, we have given your lordship. It is AIR 2022
3386.
3386. If my lord will kindly. Ours is Manu Batra. If your lordship can turn to paragraph 43. Flag mark. We have flag mark. A suspension of sentence is an act of keeping the sentence in abeyance. My lord, got it. 43 on the top. Suspension of sentence is an act of keeping the sentence in abeyance pending the final adjudication. Though delay in taking up the main appeal would certainly be a factor, and the benefit available under section 436A would also be considered. The courts will have to see the relevant factors, including conviction rendered by the trial court, When it is so apparent that appeals are not likely to be taken up and disposed of, then the delay would certainly be a factor in favor of the appellant. The next para, we hold that delay in taking up the main appeal or revision, coupled with the benefit conferred under 436 capital A of the code, among other factors, ought to be considered for favorable relief on bail. Then, my lord, 46, if my lord will kindly turn to paragraph 46. Section 436A of the code has been inserted by Act 25 of 2005. This provision has got a laudable object behind it, particularly from the point of view of granting bail. This provision draws the maximum period for which an under trial prisoner can be detained. This period has to be reckoned with the custody of the accused during the investigation, inquiry, and trial. We have already explained that the word trial will have to be given an expanded meaning, particularly when appeal or admission is pending. Thus, in a case where appeal is pending for a longer time, to bring it under 436A, the period of incarceration in all forms will have to be reckoned, and so also for revision. So this has been extended even to appeal and revision. 436A of the CRPC.
And what is the prima facie case on merit?
Prima facie case on merit is, if your lordship can kindly turn to if your lordship will take part 1, paper book 1, at page 218. I'll confine myself to section 20 only, my lord. Just 2-line finding I will show your lordship. The other, he has already completed this attempt. So if your lordship can have the paper book at page 218.
Yes.
Well, I'll start from 217, the last paragraph. If your lordship, 217, the last paragraph. However, the prosecution has failed to prove charges under section 10D of UAP Act against the accused person by cogent and convincing evidence, as though the prosecution has established the fact that the person remains member of unlawful association. They voluntarily promoted and aided object of such association. Now, this is important, but none of them were found in possession of the unlicensed firearms, ammunition, explosive, or other instruments or substance capable of causing mass destructions or having committed any act resulting in loss of human life or grievous injury to any person or cause significant damage to any property. So the next, page 218. However, the fact remains that the accused persons were a member of the terrorist organization. As such, they can be convicted under section 20. So the only finding is that they are a member of the terrorist organization. Now, for a second, if your lordship will take up my compilation, Miller. Compilation, Miller. At page 13, your lordship will find section 20. Because there are dual requirements of this kind of compilation. There are
30 of the compilation.
Yes. There are dual requirements under 20. If for a second also it is assumed that they are able to establish during trial that he is a member, then also the conviction will be bad. Your lordship may turn to page 13. Section 20.
Page 13.
13. Punishment for being member of a terrorist gang or terrorist organization. Any person who is a member of a terrorist gang or a terrorist organization, your lordship will kindly mark it, which is involved in a terrorist act, shall be punished. There is not even an iota of evidence and no finding. Your lordship has seen at page 218. He is a member of terrorist organization. even if suppose, my lord, assuming for a second that they are able to establish during the hearing that yes, he's a member of terrorist organization, even then the second requirement is lacking. And then it will be covered by Kalpanath Rai's case. Kalpanath Rai's case was also charged. Being a member of terrorist gang, he's involved in terrorist activity. Supreme Court says where it is. It was not found and he was acquitted. That decision also have annexed that I will show later. Now, for a second, if my lord will come to paragraph 11 of my bail application, because this is where the hearing was stopped. And I'm sure, my lord, this will not take more than half an hour for your lordship to dispose of after it is taken up. At least this provision. Paragraph, my lord, 10, at page 7 of my petition.
Yes.
That applicant respectfully states that organization UPPK is neither mentioned in the notification dated 13/11/2013 issued under section 3(1) of the UAP Act, Exhibit 76 as unlawful association, nor the said organization is listed in the schedule of UAP Act as terrorist organization, which is main ingredients of section 20 of UAP Act apart from other ingredients. Section 2M of UAP defines expression terrorist organization, according to which the said expression means an organization listed in the schedule or an organization operating under the said name as the organization so listed. So, my lord, on this, your lordship called upon my learned friend to show where it is. If it's not in the schedule, how can you, my lord, call it a terrorist organization? So that schedule cannot be changed. And there are clear findings that I separated, that the appellant separated from PRIPAC and formed its own group known as UPPK. And it is given in the charge sheet and also finding. If your lordship permits me, I'll take your lordship through that. Your lordship may take part 1 first. The charge sheet at page 297, my lord. 297. And the relevant page will be 307. 307. Third para, my lord. I'm pleasing, my lord. The relevant first, let me place, my lord. Third para, 4th line from the bottom. 4th line. This is charge sheet, this is their base document. However, your lordship, 4th line from the bottom of third para. However, another faction led by Defense Secretary N. Shanti Meti, he is the appellant before your lordship. So and so managing the managing of General Secretary faction split off to form PRIPAC Shanti later on 6th November 2008. The PRIPAC faction was renamed as United People's Party of Kangleipa. So this is their own case, that I am UPPK. And same finding is recorded by the court. If my lord will kindly, I'll take your lordship to 196, page 196. 196. 196, third paragraph. In early 2000, the group again is split into 2 factions. My lord got it, third paragraph.
Yes.
Into 2 factions, one headed by General Secretary, the other by Vice Chairman. In 2006-2007, both the factions, PRIPAC, were reunited. However, another faction, my lord kindly mark it, another faction led by Defense Secretary Shanti Meti, man gang of General Secretary faction is split off from PRIPAC Shanti. And later on 6/11/2008, this PRIPAC Shanti was renamed as UPPK. So this is the finding of the court. Your lordship has seen the charge sheet. And one more thing, the last thing which I would like to show to your lordship is MOU. There is an MOU with the UPPK, Government of India and Manipur, which will, my lord, conclusively show that the group is UPPK, has nothing to do with PPAC. And that your lordship will pick up the main paper book, my lord, at page 146, paper book 2. (147). (147). My lord, your lordship first take up 149. The pages are not in seriatim. One memorandum of understanding. 147 is the, my lord, heading memorandum of understanding between Government of India, Government of Manipur, and United People's Party of Kangleipak. This is Exhibit 19. This is their document. The very opening of the MOU is, my lord, whereas United People's Party of Kangleipak operating in the state of Manipur have come forward for the peace talk with the Government of India. Therefore, my lord, my submission would be that the prima facie, it is clear that we are not PPAC. We are separate organization, which is neither listed as unlawful association nor terrorist organization. These are not, this is not listed. The list cannot be changed now. There cannot be any improvement. And the second point would be only for section 20, others he has already undergone. So far as 20 is concerned, the other requirement is that the organization must be indulging in violence. There is not even one which is sent for trial where UPPK is indulged in violence. So coupled with this, my lord, and also read with 386A, my lord, 436A, my lord, beseech your lordship to kindly grant them interim bail.
CRPC. How many persons were convicted here total?
My lord, four. Four all are before your lordship.
So all are seeking bail.
All are seeking similarly situated. They have also completed 5 years.
And all have been convicted for a jail term of 10 years.
10 years maximum.
Sentence.
Yes.
Charge was under which sections?
My lord, charge, your lordship, kindly see. My lord, charge was
Charge framed by the court.
my charge was framed by the court. My lord, one was section 20, volume 1, it is given, my lord.
And the other is?
Section 18. There is no finding, nothing is written about 18. 20, 18, 38.
38. And 10.
And 10A and 40. My lord, out of which I made 10A, 20, 38, and 40 are under UAP Act. Then 120B IPC, and conviction is section 20 UAP read with 420. 120B. And the other is section 386. 386 extortion, where sentence was 5 years.
So conviction is under section 20 of the UAPA read with 120B of IPC.
Yes. And section 10A for 1 year. Section 10A.
No, the court says prosecution has failed to prove charge under section 10D.
B, actually, it is not, should be have been B, because B is a graver charge where they are indulging in violence. So therefore, my lord, 217, I'll take you to your lordship. There says there is no evidence that they have indulged in any killing.
So where is the ultimate finding of the court?
My lord, at page, my lord, 218, I have shown your lordship. Then your lordship may turn to page 279. 279.
Yes.
I'll start with page 278, last paragraph. From the above discussion, it is apparent that the prosecution, by adducing cogent and convincing evidence, has succeeded to establish the fact that PREPAC UPPK is a banned organization whose objective was to secede from the Union of India by separating Manipur by unlawful activities. It is further succeeded to establish that the accused persons, namely A2 to A4, were members of this banned organization, and all of them entered into criminal conspiracy to do illegal acts, that is, waging war against the country. No charge under 121, my lord. Waging war, no charge. Waging war against government of India. As such, they all convicted under 120B. They are also convicted for committing crime punishable with section 10A. My lord, here 120B, as if it is independent section. I will show where he says 20 read with 120. 286, I'll come to that. Second para, the prosecution has further succeeded in establish the fact that all the accused persons were a member of this terrorist organization, and by being associated themselves with the terrorist organization, they further its activity and committed offense relating to membership of the organization. Accordingly, they are all convicted under section 20 and 38. Then the prosecution has succeeded in establishing the fact that accused number A kidnapped PW12 and kept him in detention. Being surrounded by armed cadres of terrorist organization, he extorted ransom amount of so-and-so for release of PW12 from his captivity. As such, accused 1 has committed the offense of 386. The prosecution has further succeeded in establishing the fact by leading cogent and convincing evidence that both A1 and A2 forged various documents to obtain Indian passport, as they were used to forge documents as genuine one for obtaining Indian passport and relating to opening of accounts, making investment business, and making properties. They have also impersonated themselves and cheated the government of India by obtaining Indian passport, and accused number 1 has cheated others in the matter of investigation and opening accounts, and thereby dishonestly and fraudulently cheated the government agency, including through the forged and fake documents. As such, accused number A and 2 are convicted for commission of offense under section 468, 471, 419, and 420. Evidence on record has further proof that A1 has committed an offense raising fund for terrorist organization with intent to further its activity, and as such is convicted for commission of offense under section 440. Then if your lordship will come to page 287, your lordship will see the sentence. Your lordship will see the sentence. From above, it is apparent that the court must take utmost caution while imposing sentence upon convicts. It cannot show much leniency or soft pedal the wheel of the justice in terms of sentence. Thus, having taken into account all these aspects of the matter as regards the nature and gravity of offences, the mitigation and aggravating circumstances that surfaced in favor of the accused during sentence hearing, having convicted all the accused person and sentenced them to RI for 10 years and fine of rupees 10,000 each to suffer SI for 6 months each under section 20, read with 120B, if your lordship can kindly mark 120B. They are further sentenced to RI for 1 year each and fine of rupees 3,000.
Okay, now earlier bail applications have been rejected.
Earlier rejected.
How many times?
2 times. 2 times, and 1 time your lordship said that the 2 division bench has already given some finding, so we'll take up the hearing. That was in last year, December.
The dates of the orders are mentioned in your IA?
Mentioned there is, but we'll give your lordship. We'll give. My lord, one more thing I would like to show. The finding, my lord, of the learned court below as to how, my lord, the persons are a terrorist organization. Your lordship will kindly turn to page page, my lord, 200, my lord. Rather 199 second para. The Lordship got 199 second para. Thus, from the evidence of this witness, it is manifest that A1 attended homecoming ceremony on the strength of SS General Secretary of PREPAC UPPK. I don't know from where PREPAC is coming because your Lordship has seen MOU. It is UPPK. Now, this is fantastic. If ever UPPK was a separate organization, he would not have attended this ceremony. I am leading, my lord, according to them, I am leading UPPK. If I don't attend and sign, who will sign? So this is the finding. If ever UPPK was a separate organization, he would not have attended the ceremony because signature to MOU signed between Union of India, Government of Manipur and PREPAC UPPK. No, it's UPPK. It's misreading, my lord. It is interesting to note that no suggestion was given to this witness regarding that, of course, cross-examination, that you have not given any suggestion. But that will not make a difference because this is purely based on conjecture and surmises because the learned trial court, my lord, having found that they are not mentioned in the either in the notification dated 13/11/2011 or in the list of in the schedule as a terrorist organization. This is there because of this. So it can't be, one cannot be declared a terrorist organization on the basis of conjecture and surmises, or inferential conclusion cannot lead to that unless they are there in the schedule. But 5 years they have already gone. And with this prima facie case in the evidence which I'll take your lordship through, the lordship will see that there are every chance that this appeal will succeed. There is only section 20 left and 5 years of 4 years, 11 months imprisonment.
Other sections they have already served.
Already served. Because your lordship may just note, my lord, 10A was, they were convicted RI for 1 year. Page 4 of the petition, I'm told, my lord, the chart is given. Bail application, page 4, if my lord will kindly take up.
Yes, just a minute.
Section 10A UAP Act, 1 year. Section 20, 10 years. Section 38, 5 years, it's already gone. 40, 5 years, already gone. 386, 5 years, already gone. 490, 419, 420, 468, 471, 2 years each count already gone. So what is left is 10.
Only the sentence under section 20 of UAP read with 120B is.
Only that is there. There also we have more than half. We have already completed.
Yes.
Previous date, my lord. Your lordship wanted the previous date. My lord, IS 600 of.
Can you just give the dates?
Yeah, we will give.
Okay. Lordship, this petition, your lordship.
1 minute, just 1 minute. You take down. We'll just take the names of who is A1, what is his name?
Yes. My lord, A1 is N. Shanti Mehti.
N. Shanti Mehte.
My lord.
A2.
A2 is L. Jiten Singh.
L. Jiten Singh.
My lord, A2 is here appellant. A2 is my lord Inocha Singh at serial number 4. Item number 4. They have filed the bail application.
Just a minute. How many bail applications are here today?
My lord, 4.
4.
2 we have filed yesterday and 2 were pending from before. Before the other lawyer had filed, that is pending. That is IA, my lord.
First, let us see what is the name of the applicant in IA criminal 597.
N. Shanti Mehti.
He is the A1.
A1
referred to in the judgment.
Yes.
Number 2, likho. Applicant in which is the other IA?
My lord, the other IA is item
number 4.
Yes, 600 of 2022, item 4. Inocha Singh,
IA criminal
600,
600 of 2022.
my lord.
It was filed yesterday. Who is the applicant there?
Inocha Singh,
Inocha Singh.
Inocha Singh
He
is A2.
A2-A2. Then which are the earlier applications?
Earlier is criminal 16 of 2019.
A3.
That is A3, Jiten Singh.
IA criminal
16 of 2019,
16 of 2019
my lord,
by A3.
by A3.
His name
My lord, his name is L. Jiten Singh.
L. Jitan Singh. And other application?
Other application is, my lord, IA criminal 37 of 2019,
IA criminal 37 of 2019.
19. E. Bobo Singh. E. Bobo, it's written here.
E.
Three.
Bomo Singh, he is the A4.
E. Bobo, my lord, not Singh, it's not here.
E. Bomo,
Huh.
the
Item
A4.
3. Item 3.
Okay. Ilangam Bobo.
Correct.
Ilangam Bobo.
Who is it?
Yes. Yes. All the applications of A1 and A2 were earlier rejected twice.
Yes.
And application of A3 and A4
Also once rejected, then the
Once-
second time.
to give this.
We'll give.
Yes, Mr. We are only on the bail.
Lordship,
More than 5 years, half the sentence.
whatever he has stated, 5 years completed, that's,
What else is there for now?
no, there is one small thing. If your lordship will take the CRPC also. Here,
CRPC. Where is the CRPC? All right.
389.
Yes.
Lordship, pending any appeal by a convicted person, the appellate court may, for reasons to be recorded by it in writing, order that the execution of the sentence or the order appealed against be suspended, and also if he is in confinement, that he be released on bail on his own bond. Provided that the appellate court shall, before releasing on bail or on his own bond, a convicted person who is convicted of an offense punishable with death or imprisonment for life or imprisonment for a term not less than 10 years, shall give an opportunity to the public prosecutor for showing cause in writing against such release. This is where lordship 10 years. So,
Basically, you are asking for adjournment.
lordship,
We adjourned the hearing at your request.
no, that,
Last hearing was on 25/4. The lordship heard this matter. And after
So,
that, 24/5.
no, I leave it to your lordship.
The only point is only
That he has completed half of his sentence, lordship, there is no dispute about it. There is no dispute.
Nothing else is
Supreme Court also
material.
says that, but this,
we'll deal with it.
lordship, if your lordship deals with it, I do not have any.
We'll deal with it. But
Lordship.
we'll have to refer that when these matters were taken up earlier for hearing, it was adjourned twice on the request of.
Once, lordship.
No.
And my senior friend did not object, lordship,
And on facts, you're not disputing anything.
that more than half of the sentence he has, that lordship I cannot.
And if we release them, what should be the terms?
Now,
Earlier also they were on bail,
Hmm.
and any terms which your,
What was the earlier term?
the lower that was granted by the trial court. So, but then I think we have annexed. We have annexed. We have annexed. At page 12, if I remember
But
correctly.
what about the other two applicants?
uh,
Their applications were pending. Did you file objection?
They have filed.
Therefore,
They have filed, my lord. It is there. It is.
yes, yes.
same objection will be applicable for them also. What else? On facts, do you have a different stand?
No, Lordship. That, so far as the sentence that they have carried out, Lordship,
No, what we are saying is the objection under 389.
Lordship.
You want to say that public prosecutor should get 10 days
That-
time.
That is there.
But the point is, these 4 applications are on the similar footing.
No, those applications were not on the 389.
389.
Was it?
389
That time
only,
they
but
were-
then
they did not
436A was not specifically pleaded. That's
But that is
question
a
of
legal
law.
issue.
Lordship.
And earlier 1 lakh, the bail was for 1 lakh at page 14.
And how many sureties?
2 sureties of like amount.
2 sureties of like amount.
Page 14 in the bail application.
All right. Take down. Heard, Mr. I'm dictating the order.
And one small fact, if your lordship permits me, I must bring it to your lordship. So far as item number 3 and 4 is concerned, our no objection was taken, but the other side is here, he could not file wakalatnama. So he requested me to be there, so
Hearing for all the applicants.
yes, today I am appearing for all.
Acha, let me write out the orders. There will be a slight change,
Well,
but you take down the order in item 1, IA Criminal 597 of 2022. 2022. Full stop. This IA, by filing this IA under section 389 bracket 2 of the Code of Criminal Procedure, 1973, the applicant herein has approached this court for the 3rd time seeking suspension of his jail sentence and for release on bail pending adjudication of the connected criminal appeal bearing number 245/2019. Stop. The applicant herein, stop, you're right. By the judgment dated 30/6/2018, passed by the learned special judge, NIA, Assam, Guwahati, in special NIA case number 01/2014. The present applicant, along with 3 others, the present applicant, bracket A1, A-1, bracket close, along with 3 others, namely L. Inaucha Singh, bracket A2, next L. Jitan Singh, bracket A3, bracket close, and Ilangbam Bobo, bracket A4, were convicted under section 20 of UAP bracket UA bracket P bracket close Act 1967, I think it is 1967, read with section 120B of IPC. Semicolon, section 10A bracket close of UAP A, semicolon, no, you write like this, sentence under convicted under 20 of UAP read with 120B and sentenced to undergo rigorous imprisonment for 10 years and to pay fine of rupees 10,000 each, 10,000 in default to suffer simple imprisonment for another 6 months. Full stop. The applicant was also convicted under section 10 bracket small a bracket close of the UAPA and sentenced to undergo rigorous imprisonment for 1 year and to pay fine of rupees 3,000 with default stipulation, comma, under section 38 of the UAPA and sentenced to undergo rigorous imprisonment for 5 years. A2 only in case of A1, it will A1 on application. A part. Under section 386 of the IPC and sentenced to undergo rigorous imprisonment for 5 years and to pay off fine of rupees 5,000 with default stipulation. In case of A1 or A2 ক্ষেত্রে under sections 468/471/419/420 of IPC and pay fine of rupees 5,000 with default stipulation. Under section 40 of UAPA, it is called A1 under section 40. He sentenced to undergo rigorous imprisonment for 5 years. Stop. All these sentences were to run concurrently. Full stop. Aggrieved by the impugned judgment dated 30/6/2018, the applicant as appellant had preferred criminal appeal number 245/2018, which is pending disposal before this court. The applicant had approached this court earlier by filing similar applications numbered and registered as so-and-so and so-and-so. You give the numbers to him. Full stop. IA criminal so-and-so was dismissed by the order dated so-and-so, and IA criminal so-and-so was dismissed by this court by order dated so-and-so. Notwithstanding the same, the instant application has been filed once again, primarily by invoking section 367.
My lord, 86.
Which is 363?
My lord, 436A, capital A.
436
capital A.
of the CRPC. The ground that applicant has served the jail sentence in respect of conviction under all the other provisions, and insofar as if conviction under section 20 of UAP read with 120B of IPC for a period of 10 years is concerned, here also the applicant has spent more than 5 years in jail. Full stop. By referring to the statements made in the IA, Mr. D.K. Mishra, Mr. D.K. Mishra, learned senior counsel assisted by so-and-so, or Mr. R.K. Dev Chaudhary, learned assistant solicitor general of India, appearing for the respondent. Mr. D.K. Mishra, learned senior counsel for the applicant, submits that there is no dispute about the fact that the applicant has served more than half the maximum punishment awarded to him. First of, in view of the decision of the Honorable Supreme Court rendered in the case of Satyendra Kumar Until versus Central Bureau of Investigation and others, rendered in connection with so-and-so, Mr. Mishra submits that since the final hearing of the appeal is likely to take some more time, the present is a fit case where the applicant deserves to be allowed on bail. It is also the submission of Mr. Mishra that his client was earlier released on bail, but he did not violate the terms and conditions of the bail and surrendered after the impugned judgment was rendered. Full stop. On merits, Mr. Mishra has fairly submitted that although the issues were earlier considered by this court, yet the fact remains that the learned trial court had convicted the applicant under section 10, under section 20 of the UAPA, merely on the ground that he was a member of a terrorist organization called PREPAC.
PPK.
However, in the charge sheet itself, the investigating agency has made it clear that the applicant was not a member of PREPAC, but a member of United People's
Party of Kanglai Park. We'll give the name.
United People's Party of Kanglai Park, bracket UPPK, full stop. There is no notification under the provision of UAPA Act declaring UPPK as a terrorist organization, nor is there any finding recorded by the learned trial court as regards involvement in any terrorist activity. If that be so, the conviction of the applicant under section 20 of the UAPA, read with 120B, is unsustainable on the face of the record. Full stop. Since the face of the record, on such ground, the learned senior counsel has prayed for releasing the applicant on bail pending disposal of the connected appeal. Full stop. Mr. R.K. Dev Chaudhary, learned Deputy Solicitor, or you should Deputy Solicitor or PP, Special PP?
No, Deputy Solicitor.
Deputy Solicitor General of India, appearing for the respondent, has submitted in his usual fairness that save and accept the sentence imposed under section 20 of the UAPA, read with 120B of the IPC. The applicant has served the jail sentence in respect of in respect of the convictions, in respect of the convictions under all the other sections. Full stop. Mr. Dev Chaudhary further submits that he is not denying or disputing the fact that the applicant has already served more than 50% of the maximum sentence of 10 years awarded under section 20 of the UAPA, read with 120B. By referring to section, which is that section?
389.
389 is CRPC. Mr. Chaudhary submits that since this IA has been listed for the first time today, he be granted 10 days time to file objection. We have considered the submissions made by learned counsel for both the sides, have gone through the materials available on record. Full stop. As noticed above, there is no dispute about the fact that the applicant has already served more than 50% of the jail sentence. Full stop. To be precise, the applicant has already remained in jail for 5 years, 1 month, 15 days on the date of filing of this IA, which is 28.
As on today, my lord. We calculated
As on today. Full stop. Insofar as the convictions and sentences awarded under the other provisions as noticed above, it is the admitted position of fact that during the pendency of the appeal, the applicant has served the entire jail sentence. Full stop. Full stop. Full stop. From a careful reading of the impugned judgment, we find that the learned trial court has not recorded any finding as regards involvement of the applicant in any terrorist activity. Full stop. Moreover, it is also apparent on the face of the record that according to the prosecution case, the applicant was a member of United People's, what is this?
Party of Kanglei Park.
UPPK, which is not a terrorist organization notified,
Or a terrorist, or an unlawful association.
is not a terrorist or an unlawful association notified within the meaning of the provisions of the UAPA Act, full stop. If that be so, there is a serious doubt as to whether the conviction of the applicant under section 20 of the UAPA Act would ultimately be sustainable in the eye of law, full stop. Be that as it may, the hearing of this case of the connected appeals would not be possible in near future due to various intervening reasons. Although similar prayers of the applicant were earlier rejected by this court, yet the fact remains that when those applications were moved, the applicant had not completed for a 5 years term in jail, full stop. Therefore, taking note of the law laid down by the Supreme Court in the case of Satinder Kumar until bracket Supra, we are of the view that a new ground had become available to the applicant for preferring this application for the third time, full stop. Insofar as the objection raised by Mr. R.K. Dev Chaudhary, learned DSG, seeking 10 days time, what is to be noted here in that the A3 and A4, here are naam lidibo. It is to be noted herein that the applications filed by A3 and A4 bearing numbers so and so and so and so are on the same grounds as urged in this IA, and the respondent has already filed objection in those applications, full stop. Mr. Dev Chaudhary has not disputed that the grounds taken in the objection in response to the applications filed under A3 and A4 seeking suspension of sentence under section 389 CRPC would be the same in the present case as well. First up, if that be so, having regard to the facts and circumstances of the case, and also the fact that this court is closing down for the long holidays in a day, we are not inclined to defer the consideration of the prayer made in this IA, only to allow the learned DSG to file a similar objection in this case as well, full stop. In view of the reasons discussed herein above, and having regard to the facts and circumstances of the case, we are of the view that the applicant has succeeded in making out a strong prima facie case so as to allow him to go on bail, full stop. We therefore direct that the applicant, bracket A1 on Namtu Divo, so and so, be released on bail on furnishing a bond of rupees 1 lakh and 2 sureties of like amount, 2 local sureties of
Local surety, well, he's from Manipur. I don't know whether he's able to give local surety, but he'll give sufficient surety around as a reputed person.
2 sureties of like amount to the satisfaction of the learned special judge Niyako. It is also made clear that every 15 days let them report. It is also made clear that the applicant would report his whereabouts
Imphal Police Station.
to the
Imphal West Police Station.
West Police Station at the interval of every 15 days until such time the pending appeal is disposed of. Full stop. If the above condition is violated, then the bail order will be liable to be cancelled. With the above observation, this IA stands disposed of. A2 same order hobo. A2 ক্ষেত্ৰত same order hobo. A3 is an objection of what the question. A2 নাথাকিব that part because that already objection আছে. তাতে খালি লিখিব. We have also perused the objection filed by the respondent in this IA. ঠিক আছে?
Well, few facts are there. Accused number 1, he is alone convicted under 386. The others have not.
That's right. We have written it.
And So far as accused number 3 and 4 are concerned, they are convicted only under the UAP sections, not under the IPC. We'll
Give it to,
we'll
I have already
Hello.
noted.
hello.
Check the orders, draft copies once. We don't want unnecessary,
Well.
because the court is closing down and after granting the bail, I don't want any, we don't want any technicalities.
Well.
Before signing the order, both of you
Yes, yes.
will be free to inspect the orders. If any typing error is there, we don't have time. to go through this. Please appreciate. So seeking your assistance.
Lordship.
Fact of the matter is, all 4 applicants have been granted bail. Yes. Registry to list the connected appeal in usual course. Citation. Is there a SCC citation of this?
SCC is
Yes,
not
perhaps
reported.
not.
AIR citation
AR
is there.
citation is there.
What is the AIR citation? reported?
AIR 2022 3386.
Satyendra Kumar until AIR 2000.
22.
On the top, it is there.
AIR 2022.
Just
SC.
below that Manu. Just below that Manu SC.
Acha, AIR 2022 SC 3386 citation. All right. So that's it.
Lordship has been really kind enough to.
Holding of AGM. What do you want? AGM should not be held.
No, AGM should be held, but they have refused to grant permission, Your Lordship.
That matter cannot be heard tomorrow.
Lordship, on tomorrow,
No,
yeah,
these are not important matters. You wait.
important means 30 is the last date. for-
Rejected. Yes, please. Next matter, please.
May it please, Lordship, I beg to mention item 28 of today's list on behalf of Senior Counsel Mr. Parthiv Kumar Goswami, Lordship.
Yes.
I seek an adjournment today of this motion matter,
Item 28.
28, Lordship.
Yes.
Subject to your convenience, Lordship, can it be listed on 20 or 21st, Lordship?
Yes. The learned counsel for the petitioner seeks adjournment in this case with a request to list this matter again on 21st of October 2022. Prayer allowed, list the matter accordingly. Yes.
Lordship, prayer for listing tomorrow. Yesterday we had filed it, it's registered also.
What is the matter?
Lordship, pertaining to tagging of license of fair price shop owners. Lordship, they have the requisite numbers of card holders, but they have been told that from October onwards, no more supply will be given to you, or you'll be tagged with other nearby shops who have more than the requisite number. They have the requisite numbers. Records will show that.
Yes.
My lord, I beg to mention item number 32 and 33. My lord, my learned friend is here, my lord. My lord, may be taken up immediately after vacation, my lord.
Lordship, first week of November, Lordship.
Yes.
Any day.
32 and 33.
Lordship.
Mr. J. Sharma, learned counsel for the petitioner, has requested adjournment in this matter, requested to adjourn the hearing of these matters with a further request to post these cases again in the first week of November 2022. Mr. S. Bhattaku, learned counsel for the respondent number 5, and Mr. R.R. Gogoi, learned departmental counsel, are present. We do not have any objection if the prayer is allowed.
Lordship, a date may be fixed, Your Lordship. It's an interim order.
However, the learned counsel for the respondents have requested for fixing a firm date for hearing of this matter. In view of the above and on the request of learned counsel for both the sides, let this matter be listed again when?
On
When?
fourth, Your Lordship.
Fourth is on third
Third, Your
November,
Lordship. Third will be-
3rd November 2022 as a fixed items. Yes.
Lordship, I beg to mention two petition for listing of tomorrow.
Why, what is it?
The respondent has settled the ferry ghats in respect of the respondent number 11. So, Lordship, in the meantime, if we are not protected, Lordship, they will continue to operate the ferry ghat, Lordship.
They will continue, but you have your matter tomorrow. You have it. Yes, we'll see.
Obliged, Lordship.
Maybe, Your Lordship. Lordship, I'd like to mention one item for listing, Lordship.
Listing what? For hearing?
Orders.
Hearing?
Orders, Lordship.
Orders when?
After vacation, Lordship.
After vacation. Yes, you did.
Okay.
Very please, Lordship. Lordship, I pray for listing of a matter for motion tomorrow.
What is the urgency?
Urgency is that this regard to cooperative societies election. Nomination is on date 6, Lordship.
Sorry,
Nomination is on date 6, Lordship.
nomination is on
Date 6 for the election of cooperative societies.
date 6.
Yes, October 6, Lordship.
So,
So the Board of Directors, as per the provision, it says they are not eligible for re-election, contesting in a re-election, if so specified in the bylaws. And in the bylaws, it is specified that the Board of Directors cannot be.
get your
re-elected.
matter. Yes,
Deeply right, Lordship.
yes, yes.
The order passed by this honorable court, Lordship will find at page 9. Page 9, my lord. And operative part, Lordship will find page 13, paragraph 13. 13, para 13, my lord.
Yes.
Yes, Lord, having regard to the fact situation presented on behalf of the petitioner, therein, the petitioner is at liberty to hold the AGM of the society within a period of so and so by applying for necessary permission from the respective authorities in the corporation department and the concerned district administration. The validity of the authorized such AGM shall be subject to the outcome of the this petition. Now, immediately, my lord, they have applied to the my lord, respondent authorities praying for permission. Lordship will find page 15. Seeking permission to hold the AGM, my lord, but no such permission has been provided till date.
No, that's not contempt. There's no direction to provide permission. Only liberty has been granted to.
Yes,
apply.
liberty.
Contempt case will not lie.
Now, otherwise, my lord,
On the request of Mr. M. Mondal, learned counsel for the petitioner, this matter stands adjourned and shall now be listed again after the vacation. Mr. Mondal, I don't want to dismiss it before vacation.
my lord.
There is no direction. Liberty is given, you go. If you are aggrieved, you have to file a writ petition.
Yes.
Contempt doesn't lie.
Obliged.
May I please, Your Lordship? Lordship, willful and deliberate violation of order dated 16/02 of 2022.
Page number?
Operative part at page 11, Your Lordship. Middle person, Lordship.
So what is the inquiry now?
No inquiry made, Your Lordship.
What is the violation?
Violation order dated 16/2 of 2022, Lordship. At page 11, middle person, Lordship. Here, the Honorable Court directed the inquiry carried out within 60 days. But now,
Mr. Asad, upon counsel for the petitioner, alleging willful violation of the directions contained in order dated 16/2/2022 passed by this court in WPC number 4660/2020. This petition has been filed. I perused the statements made in the contempt petition. NOM issue notice returnable in 8 weeks. Petitioner takes steps for service of notice upon the respondent by registration.
deeply obliged, Your Lordship.
Me, please, Your Lordship. Lordship, our only grievance is there. There was no order, yet the circle officer of Masbar Revenue Circle, in connivance with the respondent number 4, has illegally disposed us from our land, Your Lordship.
Already evicted.
Yes, already evicted, Your Lordship. No order. We have filed a representation.
Then we have to issue notice at this.
Yes, Your Lordship.
But Mr. T.S. Dewdy, Land Council for the petitioner, aggrieved by eviction of the petitioner from the land under his occupation, the instant writ petition has been filed. Mr. Dewdy submits that the petitioner has been evicted without following the due process of law. First up, Ms. N. Bordole, Learned Standing Council, Revenue Department, Assam, Ms. S. Sharma,
2 and 3.
Government Advocate, Assam, prays for some time to obtain instruction. NOM 4 weeks since Ms. Bordole has accepted notice for respondent number 1 and Ms. Sharma for respondent numbers 2 and 3. No formal notice is required to be sent to the said respondents. Extra copies of the writ petition be furnished to the Learned Departmental Council, requisite in numbers so as to enable them to obtain instruction. Step by registered post to Devi for service of notice upon respondent number 4.
lastly, it was, this honorable court was pleased to direct the council, my lord, to bring the report from the deputy commissioner itself, my lord.
We've written to them, we haven't received a reply as yet, my lord. Including copies have been made available, my lord. Few days' time, my lord, I pray. Pray for a few days' time, my lord.
Now, in discharging duties, my lord, this chairman is facing problems, my lord.
No, what is the order you want here?
Here, my lord, since the petitioner is discharging his duty, my lord, now they are giving, my lord, this disturbance all the time, my lord. He could not function his duty, my lord, properly. And this, the unseen force, they are applying, my lord, the response number 5, as well as some other political leaders, my lord, they are doing all this disturbing, my lord, the petitioner, my lord. At least for the developmental works of the municipal board, my lord, that has been now stagnant, my lord, because of this.
Who is disturbing? Who?
This respondent number 5, along with her some persons, my lord.
Heard Mr. B.K. Chetri, learned counsel for the petitioner. Also heard Ms. S. Sharma, learned government advocate Assam appearing for the state. Full stop. The petitioner herein is the elected chairman of Tinsukia Municipal Board. Full stop. She claims to be holding office till today and is also making efforts to carry out the developmental works under the Tinsukia Municipal Board. However, alleging undue interference and disturbance created by the respondent number 4 in discharge of her function, the petitioner has approached this court seeking relief. Full stop. This writ petition was adjourned twice so as to enable the learned government advocate Assam twice, that is on 6/9/2022 and 23/9/2022, so as to enable the government advocate Assam to seek instruction from the deputy commissioner Tinsukia as regards the veracity of the allegation. However, today also, when this matter was called up, the learned government advocate summarized that no instructions have been received. In view of the above, issue notice of motion returnable in 6 weeks, since Ms. Sharma has appeared and accepted notice on behalf of the respondent numbers 1 to 4. No formal notice is required to be sent to the said respondents. Extra copies will furnished to the learned departmental council. Stop. Petitioner to take steps for service of notice upon respondent number 5 by registered post with AD. Within a week from today, heard on the prayer of interim relief, the said prayer will be considered on the returnable date. However, as an ad interim measure, the respondent number 3 is directed to ensure that there is no undue interference or disturbance created in the normal functioning of the Jorhat Municipal Board.
Tinsukia.
In the normal functioning of the Tinsukia Municipal Board, headed by its elected chairman.
May I please? On 22nd and 9/2000.
Matters are there today.
No, Lordship, it is different, Lordship.
The state council is directed to take information regarding the 122/9 regarding the status of the, what is the position of the order dated 22.
Of the position of the
regarding the tender process is completed and the petition has become the L1. And thereafter, after justification taken,
Yes.
Lordship, as per my instruction, it is approved and sent to PWD, Lordship. PWD is the authority to award the contract, Lordship. Instruction from PWD is required, Lordship.
now it
Yes, what is your instruction?
On the last occasion, direction was to the municipal board to have the instruction.
ADC.
I can have the instruction or let it be immediately after vacation.
We should notice that in the meantime, PWD may process the tender in accordance with law.
PWD or PWD on the side of the PWD already completed the tender process. PWD completed the tender process, and then after that, a comparative statement has been made, and thereafter they selected the L1 tender. L1, L2, and what a valid tender. And thereafter, they matter is giving the CS file is sent to the municipality board for approval, because but municipal was holding the matter, and now they say that we are not the competent.
Exactly, but they say that they've awarded the contract to the L2, Keshav Chandra Bora. The deputy commissioner has said this because they were not satisfied with the justification submitted by.
They did the file an affidavit because they felt that now I have a document what is issued in the.
Are you aware that work has been allotted?
No. Even lodgeable finance, this letter was given by the EO. Which is given to.
All right, now, if the work order has been issued, you have to challenge that.
No, yes, but work order have to be issued. But they even the municipality said we have not issued it. The deputy commissioner cannot issue the work order. Work order have to be issued by the PWD.
Committee.
And PWD, that is letter also kind of say this matter is sent to the superintendent engineer, and that was kept in file for the time together on the yesterday they have sent to the PWD. Copy was given to me, and what you find here is said after reading this possible what is the intention. Under some
I heard Mr. P. Borua Learned Council appearing for the P. Borua Learned Council appearing for the petitioner.
If I come out to file affidavit, then you can consider the logic. See, their intention. They want somebody presides that they want to give it to L2. Municipality, you said whether the tender committee, evaluation committee can giving the L2. And if you want to giving to L1, is giving justification why L1, L2. That is the state lordship will find that paper. Therefore, if you come to total affidavit, then lordship everything will come. If the bias and arbitration there, then lordship have to be take the step into the respect. And lordship will read the earlier instruction. The superintendent will have to do how they can select.
Fundamental right.
But I can have the instruction by 2 melody blocks. Give me that.
All right.
Yes.
At 2.
Next matter.
If possible, if you can get it before rising of the court, that will be even better.
By half an hour.
Half an hour, after half an hour, yes.
Maybe your lordships, in this case, Gorecha College quoted a tender for construction of the your lordships hostel superintendent quarter, and all your lordship for the cost of it 32 lakhs your lordship. Here I applied for the your lordship that tenders, and accordingly, your lordship comparative chart was prepared. Page 38 your lordship. Where my bid is 9.9 below the your lordship the cost. And the tender was given to the respondent number 8, Pradeep Demari, his 5% below. By invoking the discretion, your lordship.
You have quoted how much?
I have quoted your 9.9% below. And the person who.
So we will have to find out why they have done it.
Your lordship.
So it can't be before vacation. You want it in the vacation court?
No, your lordship.
Then after vacation, let them obtain instruction.
Your lordship. In the meantime, your lordship,
We will not pass any stay order. before we'll post it for
But your
motion.
lordship,
only.
work has already been allotted, your lordship.
Yes, so if you make out a case, stop his payment. Let him do the work. Payment will be made to you, he will do the work. Heard Mr. Anand Jal and counsel for the petitioner. Peruse the amendments made in the writ petition. The petitioner was one of the bidders in response to NIT dated 14/2/2022 issued by the authorities for construction of hostel superintendent quarter, waiting shed, watchtower, boundary wall, including iron gate, etc. at the Goresar College for an estimated cost of 32,79,000. According to the petitioner, his tender was valid and he had quoted a lower rate than the private respondent. Notwithstanding the same, the work order dated 6/8/2022 has been issued in favor of the respondent number 1 by ignoring the bid of the petitioner. Hence this writ petition. Who's appearing? Who is for the BTC here? All right, then we'll state. None has appeared for the BTC. Authorities. The name of the learned standing council has been shown in the cause list. Full stop. You are appearing in this case. Issue notice returnable on 20/10/2022. Since the respondents are not present, petitioner to take steps to service of notice upon all the respondents by registered post is ready, as well as the usual process within 3 days from today. Heard in the prayer of interim reading, having regard to the facts and circumstances of the case, operation of the interim order dated so and so, work order dated so and so, shall remain suspended till the returnable date. Mr. President.
May it please your lordship. In this case, your lordship, an FIR was lodged against the present petitioner. He was arrested and subsequently released on bail. In the meantime, your lordship, the Tinsukia Municipal Board, the executive officer, has closed the godown without any inventories. Your lordship may kindly peruse.
Notice at this stage, Mr. Deori. Part Mr. T. Deori and counsel for the petitioner peruse the developments made in the writ petition. NOM 4 weeks. Petitioner to take steps for service or notice upon the respondents by registered post 230.
You respect your lordship. What has happened is that there have been occurring in my godown. Some for protection, your lordship, because thefts are occurring in my
In
godown.
the meantime, the thieves will not steal from the godown.
The police protection, your lordship. Otherwise, it's very
Let the instruction come, we'll see.
In this matter, we were supposed to place instructions. Copies were given to us on the 26th. The letter went out day before. We need a few days' time for instructions.
My lord, here whatever not the Tinsukia fish market had to be developed, my lord, and tender was floated. I got the tender accepted, my lord. And my lord, in the meantime, there was escalation of cost.
The copy was furnished when?
On the 26th.
26th. Yes. After vacation, can't help it. Because the order of the court is during the course of the day.
Yes.
Mr. Sharma, your junior.
Yes.
Heard Mr. Arti Sharma, learned senior counsel, assisted by Mr. Art Terwilder, learned counsel for the petitioner. Also heard Ms. S. Sharma, learned government advocate Assam. That due to non-furnishing of extra copies for the order of this court, she could not obtain instruction in the matter. If that be so, let this writ petition now be listed for motion again on the date of reopening of the courts after the puja vacation. Yes. If you want it in vacation court, then we can do it.
No, my lord, let it come. We will let you later get full time.
All right.
An order passed by this court. This is the second time we file a writ petition. So there's a report in the report. There is a pump which we set up in 2013. They want to set up the HPSC want to set up another new pump, which we agreed. Set up a pump by an NIT. So we said that there has to be viability report because as per 2011,
What is it?
Well, kindly see our manual, my lord. As per this manual, my lord, our per month, my lord, expected sale is to 25 KL, my lord. And we have, our SEB is to SEB the target 25 KL, my lord. It is more than that, my lord. Well, kindly see, I have submitted the instruction, my lord. At bottom, my lord, in parallel, the item number 14, my lord, 10, my
Your
lord.
lordship take a 6192, where I made a note. 61, last time also your lordship was taken.
Kobita Dastan?
6192. Next case. With a note, same case.
6192.
Just, can I just place it, then your lordship will hear it, if your lordship allows me.
No, your grievance, if the court remembers correctly,
Yes.
is that the location of a particular pump was not taken into concern before giving the survey report.
Yes,
And
my pump,
your pump was not
taken into concern. That's the main case, my lord. And when they came up before this court, I thought that my pump was there, even then I have to file a fresh writ petition, new cause of action. I took the liberty, court has given, and my pump has not been taken into account. So there is no feasibility. They didn't consult the IOC, Indian Oil Corporation. We made an RTI.
Your pump is IOCL pump.
Yes, we made a letter to the IOC, and they kindly see the letter, my lord. Kindly see the letter. All
Alright,
three,
Mr. Bhattakur,
all three has to be
this is going
consulted.
after vacation. In the meantime, we'll stay.
No, madam, kindly see, my lord. But as per our guidelines, my lord, our expected, my lord, sales per month is 25 KL, my lord. If you consider his as a petrol pump also, my lord, it gives more, my lord, kiloliter per month, my lord. It is not that, my lord, kindly say 168 for a moment, my lord. It is a feasibility report, my lord. It is the, my lord, trade area average sale, my lord. It is, my lord, MS, my lord, there is a petrol and, my lord, SSD. It is, if you total it, my lord, it is 63, my lord. It is above the expected, my lord, sale
Which report
volume.
you are referring to? This one?
Our feasibility report, my lord.
This one?
No, my lord, 168, my lord. It is our manual as per which, my lord, we done the feasibility, my lord. No, 168, my lord, kindly see, my lord. This is done as per, my lord, this manual, my lord. 168, my lord, kindly see, my lord. Trading area average sale, my lord.
Mr. Bhattakur, you are arguing cases just 2 days before vacation. Be conscious.
But
If you
because
take
my-
the court into complicated
my lord is
issues,
going to-
the straightaway order will be will stall it and examine it after vacation.
Yes, ma'am.
Because today the court cannot go into deeper issues.
Yes, my lord,
and
our instruction is that, my lord.
You
if
will get another 3 minutes.
Oh, yes, my lord.
Whatever you have to
But,
say.
my lord, kindly say, then, my lord, kindly say our instruction, my lord. It is clear, my lord.
What is the instruction? Show.
At bottom, my lord.
Which is the instruction? This one?
Yes, my lord, in last part, my lord. Yes, selection guideline, my lord, that I have provided, my lord.
So your cases as per, you have done it as per your guidelines. Their cases, you have not done it as per their guidelines. Heard Mr. D. Das, Lana, Senior Counsel, assisted by Mr. R. Sharma. I'm staying it. These things can't be decided.
Take my word, my lord, we will not go further, my lord. We will not go further, my lord. My lord, pass an interim order, my lord. My lord, we will not go further, my lord. We will not take any further action, my lord. In so further, my lord.
Then we'll have it immediately after vacation.
But there will be stay, my lord. They will go. Then they will start constructing. They will
No,
start
only, my
construction.
lord, award has been recorded.
No, undertaking to be recorded. Then
Yes,
it is
madam.
undertaking to be recorded.
Heard Mr. D. Das, Lana, Senior Counsel, appearing, assisted by Mr. R. Sharma, appearing for the petitioner in both these cases. Also heard Mr. S. Bhattakur, Lanet Standing Counsel, BPCL, as well as Mr. P. Bharadwaj, Lanet Counsel, appearing for the IOCL authorities. Full stop. The basic grievance of the petitioner in both these writ petition is that despite the order dated, which is the earlier order of the court?
Here order of the court.
174.
174. And the order is at page 181. 16/8/2022. And the operative at page 182. 182.
Order dated 16/8/2022 passed by this court in WPC number 395/2019. permitting the petitioner to the writ petition. The ground that a feasibility report be prepared as regards proposal to set up the new petrol pump. And in view of the failure on the part of the BPCL authorities to consider the pump of the petitioner while preparing the feasibility report, the present writ petition filed. Stop. Mr. Bharadwaj submits that the pump of the petitioner was not taken into account while preparing the feasibility report. The said submission has not been disputed by Mr. Bhattacharya, but according to the instructions obtained by him, there is no necessity to consider the petitioner's pump since the volume of
Expected combined sale volume 25 KL per month.
since the ceiling of combined sale volume of 25K per month will be achieved.
Yes, well.
Not be achieved even if the pump is allowed to be established.
Yes, madam.
Said submission of the learned counsel for the BPCL has however been strongly refuted by Mr. Das. First up, be it as it may, the controversy involved in this writ petition would require detailed hearing, which would not be possible today, just before the vacation. As such, issue notice of motion returnable on 1st November 2022. Since the respondents are already represented, no formal notice is required to be sent in this case. Extra copy. Achha, private respondent has to be. Since the respondent numbers 1 to 5 are already represented at the standing council, report at the board.
He is part of.
I was
included as respondent 5.
Achha, you write
Private respondent.
Since Mr. SS Roy has accepted notice for respondent number 1, Mr. P. Bharadwaj for respondent numbers. SS Roy for respondent numbers 1 and 2.
Yes, ma'am.
Mr. P. Bharadwaj for respondent numbers 4 and 5. Mr. Bhattacharya for respondent number 3 to Upper Dibo. And Mr.
Yes, Ahmed.
S.A. Ahmed.
Yes, ma'am.
Elect counsel for respondent number 6. Service of notice is deemed to be complete in this case. Copies of the writ petition be additional copies of the writ petition be furnished to the learned department council so as to bring their stand on record by filing affidavit. Let this matter be listed along with WBC 6183 of 2022 on 1/11/2022 as fixed item. The matters will be taken up for disposal at the stage of admission hearing. Parties to exchange pleadings accordingly. Taking note of the assurance given by Mr. Bhattacharya that the private respondent shall not be allowed to carry out any development the proposed petrol pump until the next date fixed. This court is not inclined to pass any interim order at this stage.
Please, my lord. In terms of the order dated 26/9, my learned friend is supposed to bring instructions on behalf of the department. I have the instructions. Because the service connection was disconnected at the request of the private respondent. It has been permanently disconnected. The service connection.
What about the temporary connection?
My lords, one thing I must point out, my lords, the service connection, the permanent disconnection has happened with regard to consumer number 0050000161154. The petitioner's consumer number admittedly is, my lord, different. The disconnection is with regard to a different consumer number altogether, my lords. No, this is the same, new and old. My lords, if my lords kindly see
Where is your consumer number? Show us.
page 42, my lords, is the bill receipt. No, my lord, may kindly, my lord, may kindly come to page 13 of my petition.
Page? Which page?
Page 13, ma'am. 13, 13. There is a old connection number and there is a new connection number, which I have mentioned. The connection number which my learned friend has mentioned is the new one.
No, it's not connection number, it's consumer number.
Consumer number.
Which is your consumer number?
My lord, this is my consumer number 005 000 16154. This is my consumer number.
What he's saying, this consumer number is standing in the name of the petitioner.
No, no, my lord.
Then
The
who?
this consumer number is standing in the name of late Rohini Devi. But before her demise, she has given her share of property to me. So since then, she has expired in perhaps in 2014.
Acha, Mr. Chaudhary, why can't you give him a temporary connection?
Malad, because I believe he already has a consumer number in his, Malad, page 42 for a moment, Malad.
I'm only seeking for a temporary connection.
42, the first part of the page.
He will get a connection by day after tomorrow.
Very well,
Let's
Malad,
continue with the hearing.
if he
You
is
will
not
have to
using,
give him.
Malad,
So all
if
this
he-
technical number, this, that, we are not getting into all this. thing.
Malad, if he
Tell us which is the best order suitable for you.
Malad,
He has to get a temporary electricity
I will-
connection.
as
must.
my lord deems fit, I'm not going to object to this.
Must.
But Malad,
You
the
can't
consumer,
deny it. Yes.
the consumer number at page 42, Malad,
Hmm.
in the name of the petitioner herein is different, Malad. It's 0050059112, Malad.
No, my
At
lord,
the bottom of the page, Malad, the consumer number that he's referring to, that is in the name of Rohini Devi, Malad. Rohini Devi. If he doesn't have a connection as of date, Malad, a temporary connection can be given to him.
My lord, payment has been made by me since her expiry.
So what about this what about this consumer number 5912?
Malad, that is in the name of the petitioner.
Mr. Dekar, do you have the correct information, instruction?
Yes, my lord, I have the correct.
What is
information.
it? Your client is having this consumer number 5912.
L. Sujata Devi, 5912, that is the consumer number.
No, my lord, my name is there because I have paid the bill. That is why. Else
What has
the-
happened to this consumer number connection?
No, this consumer number connection belongs to my house, which I received from late Rohini Devi.
You may have received for anywhere, but it is there.
It
as
is
on
there,
date.
my lord. It is there.
Therefore, you have this connection.
Yes, yes, my lord.
Then why are you asking for temporary connection?
No, because my lord, on insistence of the respondent number 4, my electricity connection has been disconnected.
On the prayer of Mr. B. Dekar, learned counsel for the petitioner, let this matter be listed again after vacation. If you do not answer questions of the court, we can't help it. I am asking you what has happened to your connection. Do you still have it or not? Is the connection disconnected? Original connection 592, is it disconnected?
Yes, my lord.
Huh? That is also gone.
That is, I have no instructions with regard to
What is the
that.
instruction you were supposed to bring?
My lords, because the disconnection is with regard to a different consumer number altogether, my lords.
When was the disconnection made?
No, no, disconnection has been made on my lord.
January 2022, my lords.
January 22.
You filed the writ petition?
No, my lord, the several negotiations were being taken place. So that has been halted, my initiative, legal proceeding.
Dekar, I'm just not clear. It's so confusing what you're saying. See, you have got taken, connection has gone from here also after here.
I'm extremely sorry, my lord. Let this matter come after vacation, my lord. I will bring the.
Yes. What
That
you
will
do
be
is, you first sit with your client and find out what is her problem.
Yes, my lord.
Then you make corrections in your writ petition.
Deeply
Then you
obliged.
come to the court.
Deeply
In
obliged.
5 minutes, you'll get the order.
Deeply
Okay?
obliged.
At the moment, it's bundle of contradiction.
Yes, my lord.
There is no problem in granting connection, but it seems you have taken a mutually contradictory stand. You want it in vacation bench or in the regular bench?
My lord, in the regular way.
All right. This case for motion again on the day of reopening.
I'm deeply obliged.
After Puja holidays.
Please, your lord. My learned friend was to produce the notification.
Yes, have you seen it?
Yes, lordship. This notification is Public Works Road Department, PWRD, 12 July. It has been observed that unreasonably lower rates quoted by some of the civil works.
I've read it, I've read it.
Yes, lordship.
So that is the problem.
Yes, lordship, but we are not PWD concerned with PWD work. And this is
an
a
order by the governor of Assam.
Lordship, but this tender process was invited for by the Dhokwakhana Municipal Board. And
Why,
My lord, the set of instruction is also there, my lord.
yes,
Reason is paragraph 4, which is stated, my lord. Otherwise, that they have below 10%, so it is not there.
oh, there is some mistake in your, that's what they say. And work order issued to respond number 5 years already completed 30%, 13%. Some mistake in your tender. Are you aware this written instruction is here? All right, you file affidavit then.
My lord.
Then we'll see.
Notice be issued, my lord.
Yes. Will issue notice, Ms. Chaudhary?
Lord.
Yes, take down hard.
My case will become infructuous in that case.
Can't help it. If there is a mistake in your tender, then we'll dismiss it. Can't be helped. We'll only see whether the authorities are acting arbitrarily or not.
Yes, Lord.
That is the law. What do you want?
Immediately on reopening. Immediately on reopening, but this, it will be subject to the outcome of the writ petition.
All right, heard Ms. B. Chaudhary and counsel for the petitioner. The petitioner is aggrieved by the preliminary work order issued in favor of the respondent number 5. Work of construction of public toilet under the Lakhimpur Municipal Board, full stop. According to the petitioner, he was the lowest bidder, but the work has been awarded in favor of the private respondent, full stop. On instructions, Ms. M. Burman, learned government advocate, submits that there was defect in petitioner's tender in as much as the figures were put incorrectly, as a result of which the work order has been issued in favor of the respondent number 5. Moreover, the respondent number 5 has already commenced the work and completed 13% of the work till date. First up, Ms. Burman prays for some time to file affidavit bringing the said facts on record. In view of the above, we issue notice of motion returnable on 27/10/2022. Since Ms. M. Burman
1 to 4, my lord.
Assam has appeared and accepted notice on behalf of respondent numbers
1 to 4.
1 to 4. No
Five
further
is
notice is required
private
for the said respondents. Extra copy will be furnished. Petitioner to take steps for service of notice upon respondent number 5 by registered post with AD as well as ordinary process. The official respondents to file affidavit on or before 21/10/2022, bringing their stand on record. Let's see if there's something.
Obliged.
Well, as per my instruction, my lord, the PWD has, though my lord, initiated the tender process and will also supervise the construction work, but we are not the authority to take a call, my lord, who will get the tender. There is a committee headed by the deputy commissioner who will decide, and they will recommend a name, and final work order will be issued by the civil engineer PWD buildings from.
You have not received the recommendation.
That part, my lord, is not there. But in fact, this letter is a clarification, my lord, sought for by the executive officer, Jorhat Municipal Board. It's not in my lord.
Process, but no work order till the next day. Heard Mr. P.P. Barwal and counsel appearing for the petitioner. According to Mr. Borua, his client is the L1 bidder, but the respondents are proposing to issue the work order in favor of L2 bidder for construction of modern fish market at Jorhat at the estimated value of 2,40,999,999.27 for reasons other than bona fide. On instructions obtained, the learned departmental counsel submits that although the tender is being processed, no recommendation.
Recommendations have been given, my lord. The tender committee has said that they are not satisfied with the justifications submitted by the petitioner, and they've decided to award the work to the L2
Submits
tender.
that the tender is being processed, but the
Yes.
tender committee is not
Yet to
satisfied
issue the work order.
with the justification furnished by the L1 bidder. Full stop. Therefore, there is a possibility that the work order may be issued to the L2 bidder. Full stop. The learned counsel for the petitioner, however, submits that there is complete non-transparency in the evaluation of the tenders, and therefore an interim order is called for. Full stop. Issue notice of motion returnable on 1/10/2022, 21/10/2022. Since who is appearing for whom?
1, 5, and 8, my lord, I appear.
Since Ms. S. Sharma, learned advocate Assam, has appeared and accepted notice for respondent numbers 1, 5, and 8, and Mr. D. Gogoi, learned SC PWD for respondent numbers
2 and 3.
2, 3, and 4. 2, 3, and 4.
3 and 4.
No formal notice is required to be sent to the said respondents. Because this R. Decca has accepted notice for respondent numbers 6 and 7, and therefore no formal notice be sent to the said respondents as well. Full stop. The petitioner to furnish extra copies of the writ petition. 6, 7, and 8. District Screening Committee, Jorhat. Who is for 8?
8, my lord, I appear.
Actually, S. Sharma, 8 also. Write it once and no formal notice. Once only write. No extra copies, full stop. Hard on the prayer of interim relief. It is provided that the respondent may process the tender but shall not issue the work order till the returnable date. Full stop. If the decision is to award the work to any other bidder except the L1 bidder, in that event, the departmental authorities shall file affidavit bringing the reasons on record for doing so, and also produce the records on the next date fixed. This case again on 21/10/2022 as a fixed item. Yes, sir.
Mr. Lawson, as per the last order, I was required to communicate the last order to the deputy commissioner, provide the instruction, which has been done. Today morning, it was being telephoned to me that they are ready to provide the instruction, but they need the copy of the petition once more time. So, some time may be granted to us. So
we have given the copy of the petition.
We have to provide it, not for me. At least the soft copy, Lordship.
Lordship will kindly see. I have a IFL on license since 2006. That number, pata number has been mentioned in the Lordship page 23.
Mr. Goswami, only problem is the vacation.
No. There is no dispute, Lordship. That is why they are.
No, the only problem is the vacation. Because his prayer is not unreasonable. Heavens will not fall if 2 days time is given.
I'm not.
The problem is the vacation.
No, I am not asking for anything, Lordship. I am submitting one thing, Lordship. Lordship can see only one thing, Lordship. For 1 minute. Lordship will kindly see what is the allegation. Allegation is that land is agricultural land, so it should be issued by private party. Lordship kindly see page 23 again. Only one time.
The writ petition cannot be disposed of today. Come so late, just before the vacation. These are the things they might do it deliberately also.
Lordship, that is why, Lordship. My submission will be, Lordship, I have a license from 2006. I have been directed to SIP because from 200 meters from National Highway. Earlier license was DAG number 130. DAG number, Lordship will find page 23. DAG number 301.
Mr.
Number 101.
Goswami, I will hear you. You make your submission. But I will tell you why a mandamus cannot be issued in the blank.
No mandamus, Lordship. I am playing, Lordship, interim order only thing is, Lordship. Temporary, Lordship, this deputy commissioner has already approved. Commissioner has allowed. Thereafter, Lordship, on the basis of a private complaint.
What is the order you are seeking today?
So temporarily I can run the, Lordship.
And what is the final order you want?
If, Lordship, if the allegation is true on a private complaint, when the deputy commissioner has given the report.
You want this matter in the vacation bench?
Vacation, but Lordship, I may not be present.
And we can't help it then. We give one more extra copy.
I have given Lordship.
No, no. Provided also, there is generally required a soft copy of it, which we have to do it by email also.
So why are they doing all these things to the people?
Thing is that Lordship, it is an agricultural land, so that part has to be inquired, Lordship.
That has been already Lordship in the record. This is not an agricultural land. Existing shop was in the same patta.
Mr. Goswami, I appreciate your urgency, but the court process is such that
Only thing is Lordship may observe, Lordship. Lordship may give him time. In the meantime, they can pass the appropriate orders.
All right, if so advised. But Mr. S.K. Goswami, Learned Counsel for the Petitioner, also heard Mr. C.P.S. Gora, Learned Government Advocate Assam, as well as Mr. R.R. Gogoi, Standing Counsel, Excise Department, Assam. Mr. Borua submits that he has sought instructions from the Deputy Commissioner Kamrup and Guwahati, but 2 days further time will be required to obtain instruction. First up, the petitioner is seeking a writ of mandamus directing the respondents to allow him to operate the IMFL on license bearing number 13/2006-7. Is the writ petition cannot be disposed of without instruction being obtained by the Government Advocate Assam. That view of the matter, the petition stands passed over for the day. Just immediately on reopening on vacation, reopening on puja vacation for motion. On the next date fixed, the Learned Government Advocate Assam to positively appraise this court as to the developments, if any, taking place in this matter. First of, it is also clarified that pendency of this writ petition shall not be a bar for the respondents to redress the grievance of the petitioner in accordance with law, if so advised.
All right. My submission that way, Lordship, in the meantime, there is no bar, considering the earlier license in the same duck, same patta. Same duck, same patta. Only distance is shifted. It is for running from 2006, Lordship.
Is will pass an order, let the next day come. Mandamus for passing a
So, Lordship,
mandamus.
I understand. Lordship. I understand. I cannot.
Technical reasons.
Only
Court
delay.
process is not like administration.
Delay has been caused because of some private complaint via the grass. That is why this complaint is
You may
made.
be correct. That's what I said.
And he has not disclosed his identity, Lordship.
Mr. Goswami, if on Monday we dispose of the matter, do you have any problem? Will you come to court on Monday? That's the problem. Why don't you come on Monday? So we have no option but to have it after vacation. These matters when filed just before vacation.
I have to submit only
Respondents will
because
take
of.
advantage. This matter could have been brought 10 days back. What to do? Next matter, please.
I have obtained instruction, what's it may dispose of the writ petition, directing the authority to revoke their registration, to restore their registration, subject to filing of the return up to date, along with the tax if any, fine and penalty, as per Rule 23 also.
To filing of up-to-date return.
Returns, then tax amount if any, along with interest, penalty and late fee.
Anything is due, my lord, will pay. My lord. Anything due will pay, my lord.
As per Rule 23 also.
Along with interest, penalty.
Penalty, fine.
As per law, my lord. Whatever due, my lord.
Late fee, as per section 23 of the Rule 20.
23 of?
CGST rules 2017.
You have a copy.
First proviso to Rule 20.
All right, take down. Heard Mr. B. Chakravarti, Learned Counsel for the petitioner. Also heard Mr. S. C. Kyle, Learned Standing Counsel, GST authorities appearing for the respondents. The petitioner firm is engaged in the business of executing and therefore is an entity which is required to have GST registration. The petitioner had accordingly obtained GST registration, but due to certain reasons beyond the control of the petitioner, which includes the aftermath of the outbreak of COVID-19 pandemic, the petitioner could not file its return regularly. Full stop. Situated thus, the show cause notice dated 4/1/2021 was issued to the petitioner as to why his its GST registration should not be cancelled. Thereafter, impugned order dated 2/2/2021 has been issued, cancelling the GST registration of the petitioner. Full stop. The appeal preferred by the petitioner against the impugned order dated 2/2/2021 is pending before the appellate authority. Full stop. Mr. Chakraborty submits that due to cancellation of the GST registration, the petitioner's business activities have been seriously hampered under the circumstances. An urgent order for restoration, public revocation of the GST registration, cancellation of GST registration is required to be passed by this court. Taking note of the grievance of the petitioner, this court had directed the Learned Standing Council GST to obtain instruction and appraise this court as to whether any immediate relief can be granted to the petitioner. First of today, when the matter is called up, Mr. Kyle submits on instruction that the cancellation of GST registration of the petitioner can be revoked with immediate effect if he files up-to-date return and pays the tax amount due along with other statutory dues as per Rule 23 of the CGMST rules 2017.
If any, our condition is that we have already deposited fine and everything. If anything, I will...
Mr. Chakraborty submits that his client has already deposited the necessary dues, but if any due is still payable under the rules, the same will be done by the petitioner. If that be so, there is no justification for keeping this matter pending before the court any further. Therefore, with the consent of both the sides, his writ petition is being disposed of by directing the respondents to restore the GST registration of the petitioner immediately on filing the return along with statutory dues, along with deposit of statutory dues by the petitioner in accordance with rules. The aforesaid exercise may be carried out as expeditiously as possible, preferably within a period of 2 weeks from. You need to know what is the dues.
Yes, my lord, it's being, they will let us know, my lord, will pay accordingly. Within 2 weeks.
Within a week from today.
Let's make it 10 days.
Within 10 days from today, the respondents, respondent number, who is the respondent?
Lordship, superintendent. Respondent number 3.
Respondent number 3 shall intimate the petitioner as regards the outstanding statutory dues, if any, payable by him at this point of time. First of writ petition stands disposed of.
Yes. In my case, there is no appeal pending, my lord. In my case, there is no appeal pending only. This is a difference only.
In this case, no appeal pending. Rest of them will be seen. Just see the synopsis and disposed of.
Here it will be respondent number 4, Lord.
4, my lord.
Respondent number 4 to intimate. Appeal order dated.
May I be? This is regarding contract payment, my lord. The petitioner has entrusted, my lord, by 2 work orders, my lord. And my lord, he has done this work, my lord, but payment has not been made, my lord.
Non-payment of contractual dues. But Mr. K. Uddin, Learned Counsel for the petitioner, this matter pertains to non-payment of contractual dues, which according to the petitioner is admitted amount. NOM 8 weeks. Who is appearing for whom?
Lordship, I'm for 1 and 2.
Ms. N. Bordoloi, Learned Standing Council PNRD, Standing Council Revenue and Disaster Management Department accepts notice for respond numbers 1 and 2. Mr. B. Devri, Learned GA Assam for respond number 3. And Ms. J. Gogoi, Learned SC Water Resources Department for numbers 4 to 7. Stop. Mr. B. Gogoi, Learned SC Finance Department has appeared for respond number 8. As such, service of notice is deemed to be complete in this case, extra copies, etc. Yes.
My lord, item number 18 is same, my lord.
Item number 18 same. Same part is water resources.
Water resources, same part.
Obliged.
This is also non-payment of contractual liability.
Art Mr. N. Katania, counsel for the petitioner. This matter pertains to non-payment of contractual dues, which according to the late petitioner is admitted amount. Issue notice returnable in 8 weeks. Mr.
S. Nyogi.
S. Nyog, Learned Standing Council,
Tiva
Autonomous Council, has appeared and accepted notice on the respond numbers 1 and 2. As such, no formal notice, extra copies, etc.
Item 19 is also same.
Item 19 also Tiva.
Tiva.
Yes.
My lord, this is also similar matter, my lord.
Contractual dues.
No, non-payment of bill.
This matter pertains to non-payment of contractual dues, which according to the petitioner is admitted amount. Had Mr. P.K. Burman, Learned Counsel for the petitioner, issue notice of motion 8 weeks, etc. And just telling you the names. Who is for whom?
Item number 20.
Learned Government Advocate Assam. For respond numbers?
All the responses I see, Lordship.
The respondents. No PWD here.
Finance, respondent to finance.
Respond number 3, Mr. B. Gogoi. Respond number 3, finance. No further. Then 1, 2, and then 4, 2. 3, B. Gogoi.
May I please, my lord? This is, my lord, regarding compensation of acquired land, my lord. My lord, my land of around 5 bighas have been, my lord, acquired. But all the other dues have been paid, other payment has been made. Only, my lord, 1 quota 12 lesser has been left out. Because there was a dispute with regard to the, my lord, that 12 lesser, my lord, 1 quota 12 lesser. My lord, the dispute has been ended by a decree of the, my lord, trial court, my lord. Your lordship will find
So,
that
Mr. Pang, today notice has to go in this case.
my lord,
You are aggrieved by non-payment of compensation pertaining to only 1 quota 12 lesses.
Others I have received.
Heard Mr. J. Pang, Learned Counsel for the petitioner. Respondents that acquired the land belonging to the petitioner. So pay the compensation along with and has also paid the compensation to the petitioner along with other statutory dues. The only grievance of the petitioner with regard to the fact that compensation for acquiring the plot of land measuring 1 quota 12 lesses covered by DAG number 985 of KP Patta number 138 of North Guwahati Revenue Circle has not yet been paid to the petitioner. Full stop. Paid to the petitioner, although the controversy surrounding the land has since been settled by a decree of the civil court. Full stop. Ms. N. Bordoloi, Learned Standing Council Revenue Department, and
Correspondent
Mr.
number 1.
CPS Bureau, Learned G. Assam, pray for some time to obtain instruction in the matter. NOM 6 weeks, Bordoloi for 1. What is this? Anybody for Guwahati Metropolitan Development?
Lordship, Mr. S. Bora.
As per is there.
Can you make it like Bordoloi for 1, S. Bora for 2, and CKS Bora for 3 and 4? Service complete, extra copies. Yes.
Lordship, my name, SC Revenue name.
Please mention the name of Learned Counsel for the respondents in the cause list. Yes.
As well as GMT, madam. Name is found in the copy.
Yes.
Obliged, Lordship.
Actually, my lord, the persons belonging to my lord, the scheduled caste community, my lord, they are in possession of a particular plot of land since 1954, my lord. And, they applied for settlement allotment on 5/1/86, my lord. But nothing was done, my lord. Thereafter, my lord, in the meantime, my lord, on just after 3-4 months ago, my lord, respondent number 7, 6 and 7, my lord, Lat Mandal and Gaubura. They implanted some red flags in the land of the petitioners, my lord, without any reason and rhyme and reason, my lord, and there is no authority, my lord. Thereafter, my lord, petitioner submitted the application before the respondent number 2, my lord, DC Dorang Mongoldo, my lord, but that is, my lord, nothing has been done to the said representation that, my lord.
As per their representation, they basically want allotment of land also. So let us get the instructions in this.
We'll issue notice at this stage.
Yes,
On both main and interim. Had Mr. R.S. Chauhan, learned counsel for the petitioner, pending the above stated petition. Returnable in 6 weeks. Since Ms. M. Babala, learned counsel has accepted notice for respondent number 1, and Mr. Sukhdev Barua, learned government advocate, accepted for respondent numbers 2, 3, 4 and 5. Notice is required to be sent to the said respondents. Extra copies of the read petition be furnished to the learned department council. Petitioner to take steps for service of notice upon respondent numbers 6 and 7. For register post to the AD. Out on the prayer of petition, the said prayer will be considered on the returnable date. Yes.
In very, my lord, kindly.
That's what I said.
On the
Interim on the returnable date. Yes.
Oblige.
The matter released to Forest Mahal, my lord. Here are stone and sand, my lord. In this case, my lord, still, my lord, contract period will expire tomorrow, my lord. But I have been stopped from operating, my lord, from 3/9, my lord, as EC has expired, my lord. And in between, my lord, due to our 144 restrictions, my lord, I could not operate 101 days in 2016, my lord. Therefore, due to COVID, my lord, 80 days, my lord. So 181 days I could not operate, though during this period, my lord, I used to pay the regularly installment, my lord. And due to these all these things, I could not. I have paid my royalty. The 7030 cubic meter of sand I could not, my lord, would extract, my lord, and 3612 cubic meter of stone I could not extract, my lord, because of these holy obstructions, my lord. And moreover, my lord, this illegal mining is there, my lord. So I could not also. I was not allowed to pay 2 kistis only, my lord. In this case, my lord. 27 and 20 I could not pay because 20 kistis were there, my lord. So in between, the second issue, when after, because they give it to 5 years initially, my lord. Although my contract period is for 7 years, my lord. So there is a gap always appears. We applied before time, my lord. Even then there was a gap of more than five months, my lord. Because of that, my lord, this 6 months I am not getting for 2 installments, my lord. So I have suffered, my lord. So it may.
So issue notice.
Yes. At this stage,
Heard Mr. S.K. Mukta, learned counsel for the petition. There is the amendment made to the petition. By filing this petition, the petitioner is practically seeking extension.
Yes, madam.
Public renewal of his period for a further period of
5 years, my lord. They will. This is up to them, my lord.
On the grounds stated in the petition. First of Mr. K.P. Pathak, learned standing counsel, Forest Department, Assam, praise for 4 weeks time to obtain instruction.
180 days I could not work. That may be recorded, now. 180 days, 181 days.
Before that, before Mr. K.P. Pathak will write, according to Mr. Mukhtar, his client could not operate the Mahan for a period of 188 days due to
my lord, restriction under section 144 and COVID, my lord.
Due to restrictions imposed under section 144 CRPC as well as outbreak of COVID.
My lord.
Then so
they directed to affidavit, my lord. Because on other case, my lord, they have been directed to file affidavit.
where to instruction NOM 6 weeks. Since Mr. Pathak has appeared in accepted notice on behalf of
Respondent numbers 2, 3, 4, 5, 7 and 8.
Then Mr. CTS Bora for
1619.
Respondent number 1 and
1619.
16, 9, 10 and Mr. KP Pathak for
Respondent numbers 2, 3, 4, 5, 7 and 8.
2, 3, 4, 5, 7. All covered?
No, 11 I will take steps, my lord.
As such, no formal notice is required to be sent to the same respondent. Extra copies will furnished to the Learning Department Council. Petitioner to take steps for servicing notice of the respondent number 11 by registered post with AD. Let this matter be listed again along with
6217.
WBC number 6217 of 2022.
Yes, ma'am.
The respondents may in the
Affidavit.
meantime obtain instruction and file affidavit.
My lord.
The respondents may in the meantime file affidavit.
Oblige.
Yes.
I think the respondent. All the
Then,
I'm in the next page.
yes, on call. This matter stands passed off. Mr. S. Bora, you are for the respondent?
all the respondents.
Honorary counsel for the respondent is present. Since the petitioner's counsel is absent, this matter stands passed over for the day.
My lord, this matter relates to fishery settlement bank. I was the highest. My lord, second highest, who gave very less amount, thereby loss of 17 lakhs by the state exchequer. My lord, I have made MLA a party. My lord, at his behest, my lord, Respondent 3, that is Managing Director, Fishery Development Corporation, are issuing has issued the settlement order to a person. Well, that person is unable to do it. Well, he gave it to a different organization. There is a cash flow matter.
It has been given to whom?
It is given to Resolution number 5. My lord, you can kindly see page 8. Page 7.
Page 8.
Para 7. My bid is 7,85,000 total. Sorry. 54 lakhs 95,000 for 7 years. And you'll also kindly see his amount is 37 lakhs only. It is quoted. 17 lakhs government has incurred loss. Despite that, in the behest of the MLA, I have made him respondent. You will also kindly see para number 10. Para number 10, I usually stated page 9, para 10. Para number 9, 10.
So now, who is operating the fishery?
Nobody. Let anything status quo order, my lord, nothing be issued.
Lordship, our policy is to give the highest bidder, Lordship. This thing may not happen. We are very transparent in the bidding process, Lordship. Even I have given the assurance to this court also.
So we'll issue notice since it's come with a grievance.
We'll give only to the highest bidder. If anything happens also, it will be corrected.
Mr.
17 lakhs, not a matter of joke, my lord. Government
Counsel
money.
for the petitioner.
Status quo order, maybe.
We'll issue notice on both interim and main. Let him obtain instruction, then we'll see. According to the petitioner, he has quoted 17 lakhs more than the respondent number 5.
Yes.
In the tender process initiated by the AFDC for settlement of Pogong, Goimari, Borbel, Mill, Palan, Tamabai Samiti. No, not that. For settlement of, what is the name of the fishery?
My lord, Borbil, Khuang Borbil. Khuang Borbil fishery, my lord.
Khuang Borbil fishery. Full stop. Notwithstanding the same, the fishery has been settled with the respondent number 5 on the recommendation of respondent number 7. Even after the settlement, the respondent number 5 is unable to run the fishery. Under the circumstances, a writ of certiorari be issued, quashing the order of settlement issued in favor of the respondent number 5. Mr. P. Sharma, learned SCFDC, submits that the policy of the corporation is to settle the fishery with the highest bidder, and therefore he be granted some time to obtain instruction in the matter. Issue notice of motion returnable on 26/10/2022. Since Mr. Sharma has appeared and accepted notice on behalf of respondent numbers.
Wonderful.
CKS Borua and GA Assam for respondent numbers 1 and 2.
Only 3, Lordship. I am for only 3, Lordship. All are other parties.
Acha, CKS Borua for 1, 2 and 4. Mr. P. Sharma for 3. No formal notice is required to be sent to respondent number 1 to 4. Extra copies. Steps by registered post with AD for service of notice upon respondent numbers 5, 6 and 7. Hard in the prayer of interim relief. Said prayer will be considered in the returnable date.
Oblige, Lord. Oblige.
May I please, my lord? My lord, this is regarding construction of works, my lord, under PWD department, my lord. My lord, the tenders, but my lord, there were 16 bidders, my lord, all have offered, my lord, same amount, my lord. So all has become a L1 here. But keeping pick and choose policy, my lord, after 5 months of opening of the tender, they have issued the, my lord, what my information is, they have issued the, my lord, work order to respondent number 3, my lord. Pick and choose policy.
The LOA has been issued on my lord 35/2022. Agreement entered in 31/5/2022. So my lord,
As per
work
my
has
instruction,
started.
no work has been started. No work has been
After all
started.
this-
It will be started 100%. So we have no objection, my lord, if they follow a pick and, my lord, lottery also. So there were 16 bidders. All have offered same.
I ask Mr. J. Payam, I counsel for the petitioner, agree by the decision of the respondents to issue the LOI in favor of respondent number 3. The instant writ petition is filed. First of all, according to Mr. Payam, there were 16 bidders who had all quoted the same price, but without following any transparent criteria. The respondent number 3 has been awarded the work in a pick and choose manner, full stop. Hence this writ petition, full stop. Mr. Gogoi submits that the work order was issued to the respondent number 5 on
35/2022.
3/05/2022, and since and thereafter the agreement was also executed
On 31/5.
executed on 31/5/2022. As such, this writ petition be dismissed only on the ground of delay and laches. Be that as it may, considering the grievance expressed in the petition, this matter would call for examination. NOM 6 weeks, since Mr. Gogoi has appeared and accepted notice.
1 and 2.
On behalf of 1 and 2, no formal notice to extra
My lord,
copies.
one thing, my lord, they have, my lord, disclose everything in the website, but the issuance of work order is not disclosed in the website.
Petitioner to take steps for service of notice upon respondent number 3 by registered post with AD. Heard on the prayer of interim relief, the said prayer will be considered on the returnable date.
Yes.
It is however made clear that the issuance of work, the execution of the work allotted to the petitioner would be subject to further order that will be passed in this case. Yes.
May I please, Your Lordship, the engaged counsel in this matter is not well today.
After vacation.
After vacation.
As paid for by petitioner's counsel, this matter stands adjourned and shall now be listed after the puja vacation. Mr. S. Bora, learned count. GMC is present.
May it please your lordship. My lord, in this matter, the petitioner is challenging the settlement of fishery issued in favor of respondent number 10, rejecting the bid of the petitioner who was the highest valid bid only on the pretext, my lord, that under Rule 12, why though the individual cannot come, which is contrary to their own advertisement, where they have invited bids from individual. Matter would need some examination. So I pray, my lord, that notice be issued, my lord.
Heard Mr. K. Goswami, Learned Senior Counsel, assisted by Ms. Neog, A. Neog, Learned Counsel for the petitioner, assailing the order of settlement of fishery issued in favor of respondent number 10. The instant writ petition has been filed. Your client was the highest bidder.
Highest bidder.
Mr. Goswami submits that the bid submitted by the petitioner, that is the highest bidder, was rejected in an arbitrary manner so as to extend favor to the respondent number 10. Full stop. Mr. C.K.S. Guru, government advocate Assam place for some time to obtain instruction in the matter. Issue notice returnable on 2/11/2022. Since Mr. C.K.S. Guru has accepted notice for respondent numbers 1 to 9, no formal notice is required to be sent to the same respondent. Extra copies of the writ petition be furnished to the learned departmental counsel. Requisite in numbers. Able to obtain instruction. Stop. Petitioner to take steps for service of notice upon respondent number 10. The registered post with AD as well as usual process within 3 days from today. Stop. Hard on the prayer of interim relief, the said prayer will be considered on the returnable date. The learned government advocate Assam to produce the records justifying the decision to award the settlement in favor of respondent number 10 by ignoring higher bids of the petition.
Just one observation, the settlement in favor of R5 may, R10 may be subject to the
The
outcome. of
order
this
of
motion.
settlement of fishery issued in favor of respondent number 10 shall be subject to further order that will be passed in this proceeding. Yes.
Deeply obliged.
My lord,
We could file affidavit in 35, other 34, 36, 37, 38, my lord. I can file it within next 2-3 days, more will be required. But I have got the records ready, my lord. Shall I show it?
And my lord, so far item number 36 are concerned, my lord. Or response number 5, my lord. I have filed the affidavit today, my lord.
No, I have got no objection. I have received it. I am ready to argue. Records are there, my lord. I can put it. The records are there, my lord. You can argue.
Prima facie, it is illegal. They have admitted, their executive officer
We'll
admitted.
take up these matters at 2. Let's finish off the other cases. Yes.
The person to the NIT, my lord, petitioner is the highest bidder, my lord, and my lord, respond number 2 first, my lord, 6, 7, and 8, my lord, and 6 and 7, he's my lord, after uploading the all tender papers, we came to know that he's given the expense certificate, and thereafter complaint, and thereafter, my lord, inquiry is conducted, and their expense certificate was cancelled by the deputy commissioner, my lord. So I am the highest bidder, but now I came to know that, my lord, they forwarded to the highest bidder, my lord, to respond over 6, my lord, for settlement. Please may kindly see page, my lord.
Who is the highest bidder?
Lordship, the private respondent is the valid highest bidder, Lordship. Lordship, the matter is a premature case, Lordship. The department yet to finalize the minutes of the tender committee. It's a premature case.
Inquiry is conducted. Please may kindly see
But
131, my lord.
So you come and the decision is taken. Why have you
My
come
lord,
now?
as per my paragraph, my lord, 16, page 15, my lord, I am categorically stated that, my lord, para 16, my lord. Now they are going to, my lord, para 16, page 15, my lord. They to state on 23.
Mr. Bora, what is the order you are seeking?
I, my lord, at least, my lord, notice maybe then not to settle, my lord. Because of that, otherwise, my lord.
You have to show us the decision to settle it in favor of a particular person.
My lord, they did not give the copy, my lord. I am stating in my paragraph, my lord, in normal report, my lord. On 23/9/2000, came to learn from the office of the director, Inland Water Transport Department, that the tender of the response of 6 has been forwarded.
Lordship.
Okay, at least, my lord.
Lordship, pendency may not be about to settle the tariff services.
No, my lord. Otherwise, my lord, they are going to, my lord, settle, my lord, because of
Then
their.
you show us the material where.
Yes, my lord, the inquiry report, my lord, as well as deputy commissioner cancelled the bid, cancelled the expense certificate by the DC, my lord, due to, my lord, illegality, my lord.
Whose experience certificate?
My lord, respond number 6 and 7, my lord. They are going to settle the respond number 6.
No, but if they are not going to settle, then
my lord, that is my so thereby your lordship, my lord, at least not to finalize, my lord. Otherwise, I will, my lord, criticize, my lord.
that order cannot be passed. Why have you rushed so early? You should have waited for the decision.
Decision, my lord, they forwarded, my lord, in the vacation camp puja, my lord.
That is not a ground.
No. I'm not on
Vacation
that.
court is there.
No, my lord, they forwarded the
You have the vacation court.
No, but forwarded they say they forwarded, my lord. I know, my lord, they did not give my copy, my lord.
Forwarded, but yet to settle, yet to take it
After
in
forwarded
decision.
to the secretary, they approval.
But Mr. Anwar, learned counsel for the petitioner, according to the petitioner's counsel, this client is the highest bidder. Highest bidder.
Highest valid bidder.
After the cancellation of experience certificate by the respondent number 6 and 7. Notwithstanding the same, the department is proposing to settle the ferry in favor of respondent number 6. Full stop. Responding to the above, Ms. Bora submits that no decision has been taken yet by the department to issue the order of settlement in favor of any particular bidder. Therefore, this writ petition is premature. Stop. You are appearing. Mr. S. Kotoki, learned counsel, is appeared for the respondent number 6 on the strength of caveat. You filed caveat?
No caveat. No caveat.
Will not record. That part is not required. Ms. M. Burman, learned government advocate Assam, is present on behalf of the state. First up. It appears that no decision has yet been taken by the departmental authorities to settle the ferry with any particular bidder. However, in view of the apprehension expressed by the petitioner, this matter would call for examination. First up, NOM 6 weeks since Ms. Burman and government advocate Assam has appeared and accepted notice on behalf of respondent numbers Then Ms. MD Bora,
1, 2, 3, and 4.
Standing Council Transport Department for respond numbers 1,
2, 3, and 4.
3 and 4, and Ms.
And 9 also, Lordship.
2, 3, 4, and 9. And Ms. M. Burman for respond number 5. Service of notice is deemed to be complete on respond numbers 1 to 5 and 9. Extra copies will be furnished to the Landed Department Council. Petitioner to take steps for service of notice upon respond numbers 6, 7, and 8. Heard on the prayer of interim relief, the said prayer will be considered at the appropriate stage. Dependency of this writ petition shall not be a bar for the authorities to process the tender in accordance with law.
I am deeply obliged.
Yes, it should be them, it will be them. It should be you, it will be you. Let them take that decision. This kind of preemptive litigations were never filed earlier. Nowadays, everything is strategic. Use the courts forum for strategic advantage. People don't come to court for rights anymore. You come to court on strategic reasons.
Next day they come with a
I will
order,
file it.
interim order will consider next.
Next matter, please.
Deeply obliged.
May I please, Your Lordship? The petitioner has challenged, Your Lordship, settlement in favor of the private respondent, Your Lordship. Our case basically is this, Your Lordship.
When was the settlement order issued?
Your Lordship, it is dated, Your Lordship, 24/6/2022, Your Lordship.
24/6/2022 settlement order you are challenging?
No, Your Lordship, not 23/9, Your Lordship.
This is what?
Of Ferryghat, Your Lordship. What has happened, Your Lordship, in this case?
Ferry has already been settled.
They have settled, Your Lordship, but Your Lordship, they have not taken over position, Your Lordship. But the issue is of jurisdiction, Your Lordship. In earlier round of litigation, we have challenged the jurisdiction of the Moria Anchalik Panchayat to settle this Ferryghat on the ground that this is not fall within Kamrup district, Your Lordship. It is both the sides of the Ferryghat falls within Morigaon district, Your Lordship. The government filed an affidavit, Your Lordship. Filing an affidavit stated that admitted that yes, this is fall within the Morigaon district, Your Lordship. Entire stretch of river Kolong, Your Lordship. Now, Your Lordship, this honorable court passes an order. Initially, Your Lordship was pleased to pass an interim direction. Finally, all those matters were disposed of. Para 40 page, Your Lordship will kindly come to page 47, Your Lordship. The disposal of the order, Your Lordship. Page 47, Your Lordship. Para, then Your Lordship, this is the order, starts from here, Your Lordship. Para 8 and 9, Your Lordship. Then, Para 7, Your Lordship. However, we provide that as the claim which requires a decision be taken in the process be brought to its logical end by the respondent authority within a period of 2 months from the date of receipt of certified copy of this order. Then Para 9, Your Lordship. We are unable to accept such objection of the writ petitioner in so and leave it open to respondent to take their own decision as per their wisdom as to whether carry forward the tender notice and to bring to its logical or end or not. We are clarifying that there is no impediment in any kind for judicial order of this court as to further carry forward the same. But at the same time, we reiterate that it would be as per the wisdom of respondent authorities as to what is required to be done in the matter. If they are also ultimately this honorable court left to the discretion of the authority.
So we'll have to examine it, Mr. Thakur. You want a stay. If you can convince that the stay order will ensure your client operates the ferry, I'll pass it. Otherwise, I'll reject it. Very precise and to the point. Yes. These stay orders are, if I don't get it, you will also not get it. That kind of orders, this court will
Then
not
I
pass.
understand, Your Lordship. That I also.
That is not correct.
understand.
We are in equitable jurisdiction.
Lordship.
You don't get any benefit. Why should we pass an order to deprive someone else? This is in any case an interim order.
In fact, Your Lordship, in this case precisely because Your Lordship, the mandate of 106 of the Panchayat Act, Your Lordship, this is in violation
You
of.
may have a genuine legal issue, but we can't decide it today. For that, she will ask for time. We'll have to issue notice to this respondent. But in the meantime, you will ask for a stay order.
Lordship,
How can we pass the stay order? What benefit we, supposing they were trying to evict you, then we can consider a stay order. At least one of the litigants will be beneficiary. The stay order here will mean neither of them will be beneficiary. Why should we pass an order like this? This is an equitable jurisdiction.
Lordship, I understand your lordship, but in this case, your lordship, what will happen, your lordship? Ultimately,
Third, Mr. S. Borders counsel for the petitioner assailing the order of settlement of ferry service issued in favor of the respondent number
11, your lordship.
respondent number
11.
11. The instant petition has been filed inter alia contending that the Morigaon, which Anchalik Panchayat?
Dimori Anchalik Panchayat.
Dimori Anchalik Panchayat did not have the jurisdiction to to settle the ferry. So in support of his above argument, Mr. Bothakur has referred to the order dated
7/9/2020.
7/9/2022 passed by the learned single judge in 2022 in WPC number 4637/2022. I peruse the same. Full stop. Ms. N. Bora.
Respondent number 1, 2.
As standing counsel PNID Assam prays for some time to obtain instruction in the matter. NOM 4 weeks since Ms. Bora has appeared and accepted notice for respondent numbers 1, 2.
1, 2, 3, 6, 7, 8.
6, 7, 8.
9 and 10.
9 and 10. And Ms. M. Burman, learned government advocate Assam, has appeared for respondent numbers and 5. No formal notice is required to be sent to the respondent numbers 1 to 10. Extra copies steps were registered post to ready for service on notice upon. For number 11, the prayer for interim relief will be considered on the returnable date.
Lordship, a fixed date of this.
Is this case again on 4th of November 2022?
Yes.
Deputy Observer.
I may appear for the caveator in this case.
At page 60, Lordship order offered the personnel with page 64. It was the consenting order of all the parties. 64, madam. In view of the stand taken by learned counsel for all the sides, without commenting on the merits of the claim and counterclaim of the parties, as was projected through the pleadings, this petition is hereby disposed of by directing the President and Secretary of CC Atkila Namghar Purishana Samiti to convene the general meeting of the Namghar Purishana Samiti by circulating proper notice and by following due process laid down in the bylaws. This exercise be carried out within a
Yes,
period
so
of.
what is the issue now? Today,
And now this Lordship meeting has been held at page 80.
80.
80, madam. It is to be informed that the Honorable Guwahati High Court's direction of the order dated 1/8/22 has been fully duly complied with, and the meeting of the SGM of CC Atkila Namghar Purishana Samiti has been convened on 9/9/22. This part we have not challenged this part. Limited part, the bottom part. Now considering the prevailing law and order situation and to maintain peace and tranquility in the Namghar premises and in the district, the date of takeover and handover of the charge of the Purishana Samiti may be postponed to further date, which will be finalized after
So meeting has
discussion.
been held on 9/9.
9/9, and we have taken the charge. I have made this statement paragraph 37.
So what is the problem now?
Now that we are not this last part, my lord, this last part has this is holding the view that we have not taken the charge, and my lord, they have blocked the key of the Namghar, the opposite party. The order should be carried out with letter and spirit. They have preferred the appeal, and to the appeal they have withdrawn and dismissed. They challenged the order passed by Lordship, and they withdrawn the appeal.
You are appearing for whom?
Respondent number 8, my lord. Respondent with the caveator. Submissions, my lord.
You
Can I
are
make my
defending the order.
Yeah.
They assign the submit.
Once he finishes, I'll submit my lord.
Yes, what is it? After the meeting is held,
Just please come to page 64.
page
64, your lordship's order. Page 64,
yes.
fourth line, third line. My lord, in view of the stand taken by learned counsel and without commenting on the case as projected through the pleadings, the writ petition is hereby disposed of by directing the president and secretary of the Sri Namgar. My lord, what happened on that day? The rules, the bylaw, it was not placed by your lordships on that day. That's why lordships passed this order. Obviously, my lord, if we don't give it to lordships, how lordships will know this? I have given the rules, kindly see. The term was over in 2011 November, 5 years term. The term was over. Then after the term was over, what is to be done? It is here. Kindly see the mark person, my lord. That was not placed on that day. For my lord, English person I have given. If the annual general meeting fails to constitute a full-fledged management committee within the period, then a general meeting provide the power of to the advisory committee to manage the immediate effect. They cannot do it. It is this particular committee which it was not brought to lordship notice on that day, my lord. So lordship has directed the managing committee. Their term was over on November 2021, and the order was passed on 1/8/22, almost after 8-9 months, my lord. They were not pleased. What has happened? These petitioners responded. They filed an writ appeal. This morning I was engaged in this case. When I saw consent order, I told them, why did you file the appeal? You ought to have gone to the honorable single judge. Please this fact, my lord, this is what has happened on that day. Then your fate, whatever outcome is there.
Appeal against which order?
This particular order. So I told them, withdraw this one. This morning today I was engaged. I said, appeal doesn't lie. It's a consent order. If you got any grievance, go to the single judge. So on that basis, this is withdrawn. Now kindly this one part. Now, my lord, please come to the other part, my lord. Please come to the other part. Page 70. Please come to page 70. What a wrong statement has been made, my lord. Surprising. Page 70. Relevant parts, page 75. Page 75. The DC did not allow them to hold the meeting. So that order was challenged and lordship has issued notice only. Kindly see the last paragraph. Since Mr. S. Sharma petitioner has accepted notice of such, however, extra copy next. Petitioner to take steps for service of notice in the respondent number 6 by registered post as a code. Next, my lord. Heard on the prayer of interim relief. The said prayer will be considered on the returnable date. Leaves the matter. No direction. See what they've done. Come to the next page. What they've done, my lord. Next page. See the last paragraph. Finding no alternative, we approach the Honorable High Court has issued an order dated 31/8/22 and has fixed the date of AGM on 9/9/22. Accordingly, where is it, my lord? Where should we fix the date, my lord? See the earlier order. Only the interim order will be considered particular date. It was fixed, my lord. They issued this notice. See the vernacular. Next page. Vernacular. See the vernacular. উপায়ন্ত হই আমি পুনর আদালতত রায় বিচারে আবেদন করার 31/8/22 তারিখে
These matters will require a little time, Mr.
Just a minute. These pleas are taken in the writ appeal. And writ appeal is dismissed.
We'll take up at 2. I have to rise now.
My lord, yes, my lord.
But we'll post this matter after vacation.
My lord, hear me for 5 minutes. Because this is not a review petition. And term was not over. I will place the bylaws.
At 2.
Yes. All right, man.
Court's order, the AGM has been held. Your point is, even if the AGM is held and they are elected, they cannot now run it. That will not be possible.
No, my lord. The very first order, lordship is passed that order, my lord. When the law prescribes certain things to be done in a certain way, when the law prescribes, there should be a special committee. And this particular committee.
Law, this is bylaw.
Bylaw, but bylaw, take this the law as for this committee, my lord, for this Namdar, my lord. That is the bylaws. The bylaw provides the one, there is a situation like this. There has to be a special
That would
committee.
mean that the court order was meaningless.
No, that's why what is going to happen now? Because on the very first day, the bylaw was not placed before lordships, my lord. So the writ appeal was filed. I would run this one, knowing fully well, my lord, that doesn't lie. It has to come to lordships, my lord. So we are going to file a review immediately, my lord. So, my lord, let lordship issue notice. Let there be, since he said he's holding the post now, let there be status quo.
Who is running it now? Who is running the management?
We are running.
Let there be, my lord,
You are
let there,
running.
My lord, let
Because
there be status quo.
Just a minute, my lord.
Let there be status quo.
Then let there be a status quo if you're
Yes.
running,
Just a minute, my lord.
Sure,
Cover there, na?
you're running the management.
Yes, my lord, what happens, we are running, the problem is that my learned friend, senior friend, probably do not know that the writ appeal was filed. And on the first day, writ appeal was going to be dismissed. Delay was condoned. That took the time on 23/9/22, then on
Mr. Saikia,
27.
who is
And
running the
today the appeal is
management?
dismissed.
Yes, we are running.
We are running, we are
You
only,
are not
the
allowed
problem
to
is this,
enter.
Lordship. We are not
Let there be
allowed.
status quo, my lord. After vacation, lordship may fix the matter.
Madam, please. We should be allowed to enter to the Namgawar. The letter order should be complied with the letter and spirit. The district magistrate locked the door and did not allow us to enter to the Namgawar.
Where is the order locking the door?
My lord, yes. Yes.
Where is the order?
Impugn order, page 80, my lord. Page 80. 80 punto. Itu dia, appeal juga di sini. Page 80, my lord. The last para we have challenged. Page 80, last para.
Status quo as on today, till the next day.
My lord, then how will enter the number? Can you see what we have taken the
Then
shots?
after other matters, you argue we'll dispose of the matter today itself, final hearing. Because the relief you are seeking is the final relief.
No, my lord, then lordship.
Interim that order I
My
will-
lord, humble prayer. Let me offer our Nampitan before the number.
That order I cannot pass as an interim order. You argue today, well, here till 6 o'clock, final.
Let the interim prayer be considered on next day.
Up to you.
Yes, after vacation. Yes.
Whatever you want, I am okay. But
Yes,
Or the entire matter may be heard next.
No, no, on interim. Kabay na rahat. He's my younger brother.
you must let him.
And very
Yes, yes.
affectionate brother.
Please, Mr. Singh.
My lord, let the interim prayer be considered. Let them file the affidavit.
Achha, you don't want an order of status quo.
Because already we are, my lord, we have hold the meeting is accepted by
So that
the.
order will help you. Why are you not agreeing to that order? That is an order in your favor.
No, if. Stop. No, status quo, we cannot enter now. We cannot enter.
Now also you cannot enter.
Because if the status quo is passed, because the DC is disturbing us. We have filed the case basically against the district magistrate. And my friend is arguing the case on behalf of the respondent, private respondent.
Yes, I am staying for them only.
We are fighting against the district
Let him
magistrate.
speak.
We are challenging the order of the district magistrate, bottom person. He has given the plate of meal to take, but he left his offer, but he stopped me from taking.
So there is someone called Victor Hugo who once made a statement. I think it is Victor Hugo, if I know. He said, I may not agree with your views, but I will defend with my life your right to express your views. Mr. Nath is not allowing that. That itself is a big legal issue. You allow him, even if you don't agree, you allow him.
Lordship has seen the interpretation. Lordship's interim order will be considered what they have stated, para 22. Honorable court has passed the order, suspending the order. Lordship has passed the order, issue fixed for interim order. Where is this stay order? Para 22, page 33, can we look?
Suspended. Lordship, my learned friend, senior friend did not.
Page 75.
No.
Please 75.
No, come on, did not read the entire order. He had read a portion of the order, Lordship's order is very clear. My lord.
No, Mr. Saikia, court is with you. He must let you speak.
My lord, my prayer is that I should be allowed to offer my prayer before the Namgawar. What is the harm to them?
Achha, who is offering the prayer now? Who is doing it?
No, nobody, they are logged it.
Is it correct?
I have made this statement. They locked the door.
Mr. Sharma, is it correct?
No lock. There's no lock. My instruction, there's no lock.
If there is lock, it may be open.
That I cannot say, but impugn order said, my lord, because of law and order situation, my lord, they has not allowed to take charge of the my lord.
We have taken the charge.
Why the meeting was held? What for the meeting was held then?
That was true, my lord, because of the quarrel between Mr. Soike and Mr. Nath,
my lord.
Because of that, my lord, we have to pass this order, my lord.
One question, Lord, you did not ask us. Why there is so much hue and cry? One question, please ask me, my lord.
No, what is the
The
loss?
question is, my lord.
What is the
The Honorable
loss?
Chief Minister declared 5 crores for this Namgor. Now this committee, which term is over in 19, 5 years after, they still want to hold the post. Why? They have 5 crores.
No, the exam was held and it was heard on the first day and they consented.
Right, heard Mr. R.C. Saikia, learned counsel assisted by Mr. B.P. Bora, learned counsel appearing for the writ petitioner. Also heard Mr. D.K. Sharma, learned government additional senior government advocate Assam writ petitioners. Additional senior government advocate Assam appearing on behalf of the respondent numbers
1 to 5,
1 to 5. Mr. Nath, learned senior counsel assisted by Mr. DJ. Who assisted by whom? Mr. J. Burman has appeared on behalf of the private respondent numbers 6 to 15 on the strength of
15.
6 to 15 on the strength of a caveat.
Oh, 16 is my lord. So small it is written. 16. Page 6. On a highlight.
Mr. Sona, 6 to 16. Full stop. Mr. Saikia submits that in terms of the order dated 1/8/2022 passed by this court in WPC number 2358/2022.
Yes, ma'am.
The meeting, the AGM of the Samiti Atkalia Namghar Committee was held on 9/9/2022, wherein his clients were elected, but the respondent numbers 2 and 3 are neither allowing the elected members to take over charge, are not allowing the newly elected members to enter the Namghar. According to Mr. Saikia, the Namghar has been kept under lock and key.
Yes.
As a result of which his clients have been, as a result of which the interest of the devotees, including his clients, has been seriously affected. Responding to the above, Mr. Sharma submits that due to law and order, due to the threat of law and order situation, such a measure had to be adopted by the district administration. The learned government advocate, however, prays for some time to obtain instruction and file affidavit in the matter. Full stop. What is your submission?
My submission is, my lord, on wrong statement then before the honorable court, even today itself.
Mr. Nath, learned senior counsel for the private respondent, submits that this writ petition has been filed by suppressing material facts so as to mislead this court, and therefore his clients be also granted some time to file affidavit. Full stop. In view of the above, issue notice of motion returnable on 20/10/2022. Since the respondents are all represented, no formal
21, my lord, kindly.
21. This is the respondents are already represented. No formal notice is required to be sent in this case. Extra copies of the writ petition will be furnished to the learned departmental council within 3 days from today. Full stop. The respondents to bring their stand on record by filing affidavit on or before 19/10/2022. The prayer for interim relief made in this writ petition will be considered on the returnable date on the basis of materials available on record.
If the door is locked, then it will lock for all, not for us. So otherwise, my lord, devotees, more than 1,800 devotees are going and coming back.
It is, however, made clear that if the respondent number 2 has decided to keep the door of the sanctum sanctorium locked, the same will be made applicable for all devotees and not only for a section of the devotees.
In fact, my lord, in the impugn order, there is one line, my lord. Hand over the charge of the so and so. Further, date which will be finalized after discussing it with all the concerned stakeholders. That may be done by the district.
Pendency of this writ petition shall not be a bar for the respondent number 3 and 4 to explore a solution in the matter after discussing with all the stakeholders.
In paragraph 37, my lord, I have made the statement that we have taken the charge.
Exploring a mutually acceptable solution in the matter
My lord.
after entering into a discussion with all the
Lordship,
stakeholders.
oblige me, much obliged.
Yes, next matter. Yes, take back Mr. Nath.
Please, Your Lordship.
Yes.
My lord, my electricity connection in my shop has been disconnected by serving the letter dated 22/8/2022 to phase 38. On that day itself, this letter was handed over to me and my service electricity
Disconnected
connection.
when? Disconnected?
22nd of August 2022.
Yes. So what do you want now?
Malad, this disconnection is not in view of any default of payment or anything. What the authorities has done, there was a 145 proceeding pending, and taking into consideration that 145 proceeding, that the disconnection has been.
So what is the order you are seeking today?
Malad, temporary restoration till.
Cannot be. Why have you waited so long?
Malad, we preferred a revision petition.
You waited.
Malad, these are poor shop owners, Malad, and.
But without giving them time, I will not fix this matter tomorrow.
Malad,
and will not pass an order without giving them time to obtain instruction.
True, Malad, but
instruction means even on motion is okay.
Malad, I understand, Malad,
But tomorrow
because
is the last working day.
as that 145 proceeding has already been stayed by this honorable court. Malad, there is no if your lordship will kindly take
Can you
phase 38
consider-
for a moment.
Can you consider temporary connection?
That bylaws may direct, my lord. So temporary reconnection. And my lord, matter may, if my subject to what my lordship holds, matter may be taken up after vacation.
I had Mr. B. Kaushik, learned counsel for the petitioner, agreed by disconnection of power supply to the shop of the petitioner. The instant writ petition has been filed. Mr. Kaushik submits that an order be passed by this court to provide a temporary connection until such time the controversy in the writ petition is resolved. Mr. B. Chaudhary, learned standing counsel APDCL, submits that if an application is made on that behalf, the same will be processed by the APDCL in accordance with law. Full stop. In view of the above, let this matter be listed for motion again after the upcoming Puja vacation. In the meantime, the petitioner is granted liberty to apply for temporary connection. If such application is made by the applicant, the same be processed in accordance with law as expeditiously as possible by keeping in mind the mandate of the decision rendered in the case of
Dilip Singh, that is with regard to a landlord tenant dispute.
as
That probably-
expeditiously as possible. That's it. After motion.
Always may fix a time period, my lord. Otherwise, the authorities may sit over it. 3 or 4 working days thereafter.
Within, if an application is made by the petitioner within 3 days from today, the same be processed in accordance with law in the next 3 or 4 working days, and the temporary connection be provided in as per the norms.
High level.
May I please, Your Lordship? Your Lordship, next of kin certificate was issued by respondent number 1, Your Lordship, the office of the Deputy Commissioner, Kamrup Metro. The name of the petitioner was not included in the certificate. Thereafter, he lodged the complaint before the respondent number 1. Lordship will find the complaint at page number 16, my lord, annexure 3. My lord, this complaint was heard by the Deputy Commissioner, my lord, long back on February 2022. And it was assured that the final order was.
Next of kin certificate was cancelled.
No, my lord. This petitioner, he challenged the next of kin certificate. He lodged the complaint before the Deputy Commissioner, my lord. This complaint was taken up by the Deputy Commissioner, and it was assured that the order will be passed within 10 days, my lord. After that, that order was not passed. Then we filed our representation, my lord. We find it at page 27, my lord. We filed one representation 5/4/2022, my lord. That was not entertained. After that, again we filed another representation that is on 29/6/2022. That is at page 29.
Notice, only notice at this stage. These are not
Lordship may
matters.
kindly, if your lordship.
No, I will not dispose it. Sorry.
My lord.
Had Mr. S. Sharma, learned counsel for the petitioner, parents the amendments made in the writ petition. Issue notice returnable in 4 weeks. Since Ms. Burman and Burman, learned government advocate Asim has appeared and
1 and
accepted
2.
notice on behalf of both the respondents. Service of notice is due to be complete in this case. Extra copies be furnished to the learned department counsel. since the petitioner has made an application for cancellation of next of kin certificate issued in favor of,
Issued in favor of my lord.
and that person is not a party.
No, my lord. So
Strike
we-
off this order. On the request of petitioner's counsel, this matter stands adjourned for the day. I'll dismiss it after vacation. You want a order to be issued by the court and you don't even make that person a party? Yes.
May I please, Your Lordship? Lordship, during pendency of this petition, my lord, respondent authorities reinstated my license, my lord. This matter may be closed, my lord.
Mr. Your name, please?
H.L. Ashwin.
H.L. Ashkal, Learned Counsel for the petitioner submits that during the pendency of the petition, the grievance of the petitioner has been redressed in as much as the FPS license.
Yes, my lord.
PDS license, is it?
Yes, yes, my lord.
PDS license of the petitioner has been restored. As such, the repetition may be closed. Full stop. Ms. M. Burman, Learned Government Advocate Assam is present on behalf of the official respondent.
125.
In view of the submission made by Mr. So-and-so, this writ petition stands closed.
Most of them.
Any developments in the matter?
We may be about to rise the court also.
Mr. Majumdar?
But
what
there
order
is,
to be-
there is one development.
Yes.
The copy code details. কি হল এইটো নহয় এইটো নেকি 20 জুলাই নহয় এই ধৰ্মেন্দ্ৰ এইটোহে আছিল 13 ছেপ্টেম্বৰৰ কি দিলা তোমার কপি আছে নাকি না 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 আরে দ্যাট ইজ হ্যাঁ মোৰ 17 or 13/9 নহয় রে এইটোহে দিলে মোক I'm sorry, man. That is not the document. Different document is one. No. Oh. You ঠিক আছে It will be
These are the same things.
Yes.
On the 13th of September 2022, your lordship is.
What is the meaning of forfeiture of service?
In fact, this is an information given to the AG, and in fact, it was written to the central government. It is an intimation to the central court, and we have been requested by the government to place this proposal before the central court.
And utilize the services as ministerial staff, but these are all the foreigners tribunal members are now being sought to be used as
My lord,
ministerial staff.
what they are trying to suggest is from the second paragraph your lordship reads, my lord. Hence, the state government in political B department has requested the Ministry of Home Affairs, Government of India, to accord approval for forfeiture of the services of the members of additional 200 appellate foreigners tribunals who are presently being attached to the existing foreigners tribunals with effect from so and so onwards, and to allow utilization of their services along with 2,000 courts of ministerial staff as and when the NRC gets notified. And it is an intimation.
That you can do.
My lord.
That you can do.
My lord, the
You
state
can do
government.
whether the court agrees or not.
My lord.
That's within the domain of the government. This is not the mandate of this bench.
My lord. The state government has written to the central government, so we'll await.
Mr. Das, these are not issues within the domain of this
No,
bench.
Your Lordship. It seems so, Your Lordship.
There is no other issue.
No other issue as
Not
such.
as per the last order. Your
But
Lordship.
Mr. A. Das, Learned Counsel, Learned amicus curiae appearing for the petitioner. Who is the petitioner here? There is no petitioner.
There's no
There's no
petition.
petition, Your
Amicus
Lordship.
curiae appearing in this case. Also heard Mr. D. Majumdar, Learned Additional AG Assam appearing for the state. Miss A. Gayan, learned CGC appearing for the Union of India. Mr. R.A. Tapadar, learned the registered judicial is personally present. Full stop. It is submitted that there is no issue arising in this case which calls for immediate attention of this monitoring bench. However, Mr. Majumdar has placed on record a copy of the communication dated 13/9/2022 issued by the Joint Secretary to the Government of Assam, Home and Political Department, from which it appears that the state government has written to the Ministry of Home Affairs, Government of India, to accord approval for discontinuance of services of additional 200 members. This is Appellate Foreigners Tribunal.
Possibly that is not correct, my lord.
Appellate Foreigners Tribunal.
Definitely.
From the letter dated 13/9/2022, it is not clear as to which are the additional 200 appellate foreigners tribunals that have been referred to in the letter. Just to be that as it may, on the request of the parties, this matter is adjourned and shall now be listed again on 31st of October 2022, so as to enable the learned amicus curiae to examine the issue.
Much obliged, Your Honor. Deep, please.
Lordship, Justice Services completed to all the respondents, and I have submitted file an affidavit, Lordship. That is flag 1A.
I'm appealing for the respondent bank. You know, I've received the instruction from the bank that on the last date it was submitted that OTS proposal had been submitted. It is not till date. No OTS has submitted, and he has last paid on July 2022 for an amount of only 20,000 rupees. Total outstanding dues is 15,89,265.
Right, today it is for motion only. We'll see. You are appearing for whom?
This is one of all the respondents.
Heard, Miss, your name, please?
Lahoria.
Huh?
Please, Lahoria.
Please, Lahoria, counsel for the petitioner. It was the affidavit filed by the petitioner as proof of justice service upon the respondents. Mr. S. Datta, learned counsel, has appeared on behalf of all the respondents and submits that there is no OTS proposal submitted by the petitioner. Be that as it may, since this matter is ready as regards service, list this case for admission after vacation.
Okay. May I please, my lord? This interlocutory application is filed seeking a slight modification of the order that was passed by your lordship on 26th of September. Now, as per that order, your lordship had granted me provisional admission in the Department of Mechanical Engineering in NIT Silchar. But subsequently, I got to learn from my client that I am eligible against that course only in the first round of the seat allocation process. So today in this application, my prayer is that I may be also be given the liberty to seek to participate in the subsequent rounds of the seat allocation process, so that I can upgrade my choice of.
Right, heard Ms. D. Brahma, learned counsel, appearing for the applicant. Also heard. What about the others? You have served copies?
Yes, your lordship, I have served copies on them.
They are not present. Also heard Mr. D.K. Sharma, learned additional senior government advocate Assam, appearing on behalf of the, you are not a party here, is it? Appearing on behalf of the respondent numbers 1 to 4. Full stop. None has appeared on behalf of the remaining respondents. This IA has been filed by the applicant stroke read petitioner with a prayer to modify the order dated 26/9/2022 by means of which the 2022 passed in WPC number 5978/2022 by means of which this court had permitted the applicant to take part in the counseling process and get provisional admission in the stream of mechanical engineering as a OBC bracket NCL bracket close category candidate under the respondent number 9, full stop. Ms. D. Brahma submits that in terms of the order dated 26/9/2022, her client has got allotment of a seat in the mechanical engineering stream under respondent number 9, but it is possible that in the next round of counseling, he might get
An upgradation of his
seat allotment ranking with option to join other courses under the respondent number 9 as well. Full stop. Therefore, necessary clarification to that effect be issued by this court. Full stop. The prayer is not opposed by the learned government advocate Assam appearing on behalf of the official respondent.
But it is up to the respondent number 9.
Mr. Sharma submits that it is up to the respondent numbers 8 and 9 to process the claim of the petitioner applicant as per the norms. Full stop. In view of the above, his IA is being disposed of by clarifying that the order dated 26/9/2022 shall not remain confined only to the first counseling, but the applicant would be entitled to similar consideration in the next rounds of counseling as well, provided subject, however, to the fact that admission given to the applicant in any stream on the strength of the order dated 26/9/2022 would be provisional and shall be subject to outcome of the connected writ petition. I stands disposed of. Yes. Naina, these are the last. Wonderful matter to be heard before vacation.
Only the fail application we like it.
See, Mr. Das, are you disputing that the recourse taken by the board is totally contrary to the earlier judgment?
Yes.
Insofar as the law is
I
concerned.
think it's not correct. Board's decision is not correct. That
We'll
is
stay
true,
the
my lord.
operation of all
My lord,
the.
what I am submitting, my lord, the private respondents has to be heard. Affected parties has to be heard. Because only one matter in item number 37, private respondents, one caveat has been filed. Others, so the lordship will have to hear them. Otherwise, there is, I think, record.
I don't know why Mr. Das is bothering about the private respondents.
No, this is the law, my lord. This is
No, private respondent who appeared. One is appeared
Anybody
only.
will go, my lord.
But we'll stay the order of.
Yes, your lordship will stay.
My lord, before that, my lord, I was part of caveat
Yes,
in item number 36.
this court
my
will
lord.
only hear him because he is being to be the only affected person.
No, my lord, and the
He has filed
affidavit
affidavit.
filed, my lord. Before staying,
Mr.
my lord.
Das, if it was not a matter
Yes,
which was decided by the court earlier,
my lord.
this court would not have
Yes.
passed an interim order.
Correct, my lord. My
But
lord,
the problem, listen, please listen. We'll hear you.
Sure.
We'll hear you. You call Sharma. Call Sharma. But the problem here is, this appears to be a brazen exercise
my lord,
by the Jorat Municipal Board.
my lord.
It is in the case where the board, same board was involved and the same point was involved.
My lord.
The court has given a ruling that this is not possible,
That's
permissible.
correct. Yes.
Despite that, they do it again.
Board has changed.
May I now submit, my
No,
lord?
no, the people have changed, but the board
Man,
is the
person
same.
sense, my lord. Person sense, not board sense. Board lawyers also sense, my lord.
May I now
Mr.
submit,
Das
my
was
lord?
on the other side.
May I now submit, my lord?
Yours is item number which?
I am item number 36, my lord.
36.
Ah,
Okay,
yes.
give the
And-
record first.
In
Prasanth
Sharma. And my lord, in item number 35, my lord, our name has been wrongly shown as caveator. My lord, there, my lord, notice is not gone, my lord. In item number 35.
The notice is your honor.
Item 36, yes.
Yes, my lord. Now, my lord, here, my lord, the first tender was the dated 23/6/2022. My lord, here is a condition. Here's a condition, page 28 in the Assamese clause 29, to give it to the highest bidder. My lord, this was the condition in the earlier, my lord, where the lordship has my lord, disposed of these two by these two judgment, my lord. There, the condition was to give to the highest bidder. Valid highest bidder. Now, this condition, my lord, has been amended by issuing corrigendum. My lord, they have annexed at page 41, my lord. clause 29 to give the highest bidder, that is amended. This is, my lord, page 41, my lord, some is, but yes. In English, my lord, page 40 in the repetition. By issuing corrigendum dated 16/7/2022, my lord, that clause 29 was amended, stating that the decision of the board as per the Municipal Act will prevail. And now the board has to take a decision as per the present condition of the contract. I mean the NIT. So
so what you are saying is they will call for a NIT, but after that it is up to the board.
My lord, that is perhaps permissible as per the decision of the Silpi construction, my lord. While there is a provision for taking a decision by a particular board, issuing authority, then if the decision is in the public interest, perhaps my lord will not help to interfere with that. Yes, my lord. So, so that what I wanted to point out, that, my lord. 2020 16 SCC 489, my lord. Only 3 paragraphs, 19, 20, and 21. My lord, because, my lord, this condition was earlier not there. Therefore, since the highest bidder was not given, the honorable court was shocked and directed to give it to the highest bidder. Now, board has to take a decision. And in my understanding, my lord, the board has taken a decision in this matter on 10/8/2022. If the decision is in public interest, my lord, then, my lord, perhaps the decision,
So
if
what
it
is,
is
what is the public interest?
public interest in the sense, my lord, as per my information, my lord,
The counsel for the board says it is not correct decision. Keep that in mind.
my lord.
Now you argue. The board is saying it is not correct.
Lord, she just asked me when I'm giving a
No.
view
That's all
in the
right.
matter,
Yes.
because
That's
it
not a-
cannot be a board stand.
That's not a stand of the board.
Yes,
I
my lord.
cannot
Therefore, my lord, in my case, my lord, this item 36, there is a decision, my lord, dated 10/8/2022.
So what is the public interest?
Public interest in this change, my lord, that in the event, my lord, that they have to satisfy your lordship by showing that record and the decision that if the tender is given to a highest bidder, my lord, then, my lord, the vendors and others, there will be in the problem. Because because earlier occasion, my lord, as I am being instructed that given highest bidder and thereafter he sought for remission and 50% remission had to be given. So ultimately, my lord, that the purpose was not achieved.
No, but there is a clause in the tender that you cannot charge beyond the amount fixed by the board.
My lord,
If you seek remission, disallow it. How can that be a ground to give it to people?
my lord, so far the rate quoted by the petitioner is more than 100% of the reserve rate.
Maybe. You
Ours
suffer.
is within 33%.
Suffer,
And
security will be forfeited.
if, my lord, this only
How do we know that there has been some underhand deal? That is why.
I don't
that's
know.
the-
My lord, therefore, my lord, in my humble submission, lordship may see that decision
Yes.
of the board 10/8/2022, how they have taken, my lord. If that is in order, my lord may not be like to interfere with it. Because from 3/9/2022, my lord, we paid that, my lord, revenue, and we are in possession, my lord. And I have filed an affidavit to that effect, my lord, today morning. So far, at least my lord, this market is concerned, my
The
lord.
judgment of Minko Hazarika is reported.
Yes, Miller, reported. Miller. I have brought the reported judgment. Miller. On the very first day, Miller, I was not with it. But-
It is annexed in one of the petitions. WPC 5919,
Yes.
2022.
That is type 1 mirror, the printed copy.
And my lord,
It is reported also.
Reported.
and my lord, so far that another judgment I have placed, my lord, WPC 2060/2020. There also lordship may mark, my lord, page para 16, my lord.
That is in which your affidavit.
No, my lord, I have just given the judgment, my lord.
Yes.
Now, Silpi along with one honorable court, my lord, from this honorable. Para 16, my lord. Here also,
My lord, the petitioner quoted 55 lakhs, my lord, and the highest rate was 79 lakhs, 101. And third person, 33 lakhs, 68,000. But my lord, the honorable court, by taking note of the judgment of the Silpi construction and other judgments, my lord, they did not interfere with it because that decision, if this decision as required under, my lord, Municipal Act 148(2), my lord, if the decision is correct, then, and if the tender clause also provides for taking a decision by the board, and if the board has taken a decision, my lord, then perhaps, lordship, if the decision-making process is correct, my lord, then, my lord, lordship perhaps will not interfere in this matter, my lord. 148(2), my lord, of the Municipal Act. Here also, my lord. No, 35, no, 36. Oh, yes. বেলেগ আছিলে বহুতো বেলেগ আছিলে এজ বিলাক দিয়া কণ্ডিশ্যন Yes, my lord, that apart, my lord, there is a provision in the Municipal Act, my lord. Now, how they will deal with the hold the meeting, my lord? The board, as per section 148(2), my lord, it says, my lord, of the Municipal Act, my lord, the board, if decided at the meeting, may levy rent, toll, and fee at such rate as it may think proper for the right to expose goods for sale in a municipal market and for the use of soft stall standing therein, and also in respect of parking lot, and may also regulate such rates in respect of private markets or place used for declared by the board as a marketplace parking lot by the public notice in the locality. My lord, there is a provision to hold a meeting, take a decision.
Are you reducing the rate?
No, rate. This is the condition because of the, my lord, that corrigendum, had the corrigendum was not there prior to the submission of the bid, my lord, then it could have been other thing. Because clause 29 has been, my lord, amended by issuance of the corrigendum. Corrigendum was issued on 16/7, and the last date of submission of bid was, my lord, 29/7. Therefore,
Mr. Das, why it was given to 21st highest
The
bidder?
reasons are there, may I just point out one case?
You can just tell us.
It is because on earlier occasion, they've given remission. Organizational representations are there that you don't give it to the highest bidder, look into our fee. That's another factor is there. These are the factors, mainly because on earlier occasion, they had to give remission to the persons who were settled with the market.
Then the whole tender process becomes meaningless.
The remission was during COVID period. I'm not. During COVID period, there was remission. Very difficult on my part. Everything was closed. It's difficult, but when I asked the authorities, my lord, why did you do it? Like public representations are there, they're elected person, they work in
So,
a different.
as we stay the order of settlement, we'll grant liberty to the board to make interim arrangements till the next day, without involving any of the bidders.
Yes, Lordship,
Heard Mr. Hassan Sharma, this is item number
Lordship,
36.
because they will have to serve notice to the affected person.
Absolutely.
36.
Item 36 of Likhit. Heard Mr. Hassan Sharma.
For 35 and
Senior
36.
counsel. We'll pass individual orders in each cases. Assisted by Mr.
M. Hussain.
M.
Hussain.
M. Hussain, learned counsel appearing for the writ petitioner. Also heard Mr. B.D. Das, learned senior counsel, assisted by Ms. R. Deka, learned counsel appearing for the Jorhat Municipal Board, that is respond numbers 3 and 4. Stop, Mr. Who is the government advocate here? No, we are in item 36 now. Who is for the government? State government of Assam. They have given up. Also heard Ms. M. Burman, learned government advocate Assam, appearing for the respond numbers 1 and 2. Full stop. The Jorhat Municipal Board, that is the respond number 3, had issued notice inviting tender bracket NIT dated 23/6/2022, inviting bids for settlement of 13 numbers of markets public stands for the financial year 2022-23. That is with effect from 1/8/2022 to 31/3/2023. Full stop. The writ petitioner herein had submitted his bid for settlement of within courts Chowk Bazaar, CHOWK, Chowk Bazaar, unquote. On opening the bids, it turned out that there were 33 bidders whose tenders were found to be technically responsive for the Chowk Bazaar. Full stop. The petitioner had quoted a sum of rupees 68,41,000 and emerged as the third highest bidder, whereas the private respondent number 5 had quoted 39,65,000 and emerged as the 21st highest bidder. Full stop. Notwithstanding the same, the municipal board had awarded the settlement of the market by order dated 2/9/2022 in favor of the respondent number 5 at his offered rate. Full stop. Aggrieved thereby, the instant writ petition has been filed. Full stop. Mr. S.N. Sharma, learned senior counsel for the petitioner, has relied upon a decision of this court rendered in the case of Minku Hazarika versus State of Assam, reported in 2017 bracket close 5 GLR 6110 to submit that in exactly similar tender process floated by the Jorhat Municipal Board. In a earlier tender process for settlement of these markets floated by the Jorhat Municipal Board, similar approach was taken whereby the higher bidders were ignored and the settlement orders were issued in fact in favor of bidders who had quoted much lower price on the by referring to it, Mr. B.D. Das, learned senior counsel appearing for the board, submits that there are complaints from the public regarding high amount charged by the bidders, and last year the board had to grant remission to many of the bidders. That is the reason why a decision has been taken.
Lot of representation in the board.
Lot of representation have been received in the board, complaining about high rates collected by the settlement holders, and during the last year, last 2 years, remissions had to be granted by the board. As such, a decision has been taken not to award the settlement in favor of the higher bidders.
They have taken into consideration their experience in running the market when nobody was running.
Therefore, taking into consideration the experience of the board or the bidders?
Bidder. They are taking the experience of the bidder who asked for revision.
No,
And they want that they should again come for
What
revision.
time, the board has ran the.
The board has taken a decision to award the settlement orders in favor of bidders quoting lower price. Full stop. Responding to the above, Mr. Sharma has argued that remissions were given due to outbreak of pandemic in as much as under the terms and conditions of settlement, no settlement holder can charge rate in excess of what has been fixed by the board. Full stop. By relying upon the decision of this court rendered in the case of Minku Hazarika versus State of Assam, reported in 2017, bracket close 5 GLR 6110, Mr. Sharma submits that in an exactly similar situation pertaining to tender invited by the Jorhat Municipal Board for settlement of this market, this court had set aside the orders of settlement issued in favor of the bidders quoting lower price by ignoring the higher bidders. Full stop. The decision rendered in the case of Minku Hazarika bracket Supra, according to Mr. Sharma, would be squarely applicable to facts of this case. Full stop. As such, the interim order is liable to be set aside. The order of settlement is liable to be set aside. Full stop. Mr. Das, learned counsel appearing for the private respondent, has argued that there is that clause 29 in the earlier contract has been amended, and now it is a matter of discretion for the board not to settle the market with the highest bidder if public interest is protected thereby. Full stop. Under the circumstances, Mr. Das has submitted that the decision of Minku Hazarika Supra will not have any application to the facts of this case. I have considered the submissions of learned counsel for both the sides and have gone through the materials on record. Full stop. After a careful reading of the statements in the writ petition, I find that this is yet another instance where the Jorhat Municipal Board has issued order of settlement, where the Jorhat Municipal Board, after inviting bids for settlement of those markets, public stands, including the Chowk Bazaar, based on financial courts, have issued the order of settlement in favor of bidders who had quoted much lower rate. In the case of Minku Hazarika Supra, this court has clearly deprecated such practice and has set aside the order of settlement issued to the private respondents by giving elaborate reasoning. Notwithstanding the same mistakes have again been committed by the board. The action on the part of the Jorhat Municipal Board, apart from being illegal, appears to be contumacious or contemptuous on the face of the record. This matter would therefore call for further examination. Issue notice of motion returnable on 7/11/2022. Since so-and-so has appeared and accepted notice for so-and-so, all respondents are represented. Since all the respondents are represented, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned departmental counsel within a week from today, so as to enable them to obtain instruction. Also hard on the prayer of interim relief. Due to the reasons stated here and above, I am of the view that the instant case is covered by the judgment rendered in the case of Minku Hazarika bracket Supra. As such, as an interim measure, it is directed that operation of the impugn order dated 02/09/2022 shall remain suspended until further orders. Consequently, it will be open for the Jorhat Municipal Board to run and manage the market within course Chowk Bazar by making an interim arrangement without involving any of the bidders, including the respondent number 6. Now, the same order will go in other cases, but the councillor number.
In some case, notice has to go. Point out. In some case, notice has to
Here
go.
notice will, 36 is already, let us see. 35, who's there in 35?
34.
So let us see 34, let 34.
Even 34, isn't it? 34, yeah. Yeah, 34.
34, who is the council?
I'm appearing 34 million.
In 34, you will write petitioner's counsel, Mr. T. Chakravarti. Also, name of the market
It's BB Hall Market, my lord.
will be BB Hall Market. So, read as a synopsis or as a order of settlement is dated 3/9/2022. Same NIT, is it?
Same NIT, my lord.
NIT date is same. I would also think the petitioner was second highest bidder by quoting 20,08,250.
Respondent number
Respondent
7.
number 7 was the eighth highest bidder, quoting rupees 11,82,824. Settlement was awarded in favor of respondent number 18. Because issue notice of research 1, 2, and 3 by Ms. M. Burman, 4, 5, and 6 by Ms. R. Deca. Steps on 7 and 8. I will stay same, but it is same. Others will be same. All right. Next we move to item
Given a
35.
chart, my lord, that will, chart is there, my lord. That your lordship will help.
Still, let me just dictate here. Item 35.
35, I'm there, my lord.
Item 35, Ako, Mr. S.N. Sharma.
It is for the truck stand.
So,
Tender.
within quotes, truck stand.
Truck stand.
31 bidders. I go to number of bidders.
And the third highest bidder.
Number 34, how many bidders were there?
How many bidders were there? How many bidders were there?
Page, my lord, 10, 18 responsive bidder, my lord. Page 10.
28 bidders. That chart, 28 bidders.
In item 34.
Yes. 6002.
In item 34, I go order to leave, there were 28 bidders.
28 bidders.
A2
Petitioner
double-
is the second.
A2 double trucks 10, 31 bidders. Petitioner was third highest bidder.
Second highest.
In item 35.
35 bidders.
Item
35 and the third highest bidder.
Third highest bidder
Third.
quoting 60,01, 000.
000.
60 lakhs 1,000.
Yes. Given to 22nd. Given to.
Respondent number 5 was 22nd highest bidder, quoting 24 lakhs 30,000.
But there are other higher bidders, they have not made them party. No, I did not necessary because they have not come. How he is worried? I don't understand how he is worried. 24 lakhs 30.
Settlement order dated 02/09/2022. বাকি খিনি একে থাকিব প্রত্যেকটা অর্ডার এখানে বদলাই বদলাই যাবে so 34 35 36 over where is 37
I am representing my lord, the same MIT, same settlement order, 11 bidder, 2 cancel, 9 in trade. I am the highest bidder.
small, Mr. T.J. Monto, learned senior counsel, assisted by Mr. D. Borwa.
This is in respect of God market.
Miss M. Burman for respond numbers 1, 2, and 3. Mr. B.D. Das, assisted by R. Deka for 4 and 5. None for 6.
Six appearing.
I am for respond number 7. Mr. P.P. Borwa, learned counsel, has appeared for respond number 6. Notice na lage tetale. Etu hobo
God market.
What is the name of the market?
Jorhat God market.
Sagoli market.
Sagoli Bazar. God market.
Sagoli
Sagoli Geo God market.
Jorhat Goat Market. Settlement order is 2/9/2022. Issued in favor of respond
number 6, my lord, with the second lowest bidder.
Who is the second lowest bidder?
Respond number second lowest. I am the highest bidder.
Petitioner had quoted how much?
4 lakhs 1,700.
4 lakhs 1,700.
And
was
respond
the
number-
highest bidder. Whereas the respond number 6 had quoted 1,25,225 and was the second lowest bidder. Lowest, huh?
It is same, my lord.
So you have to notice complete, service is complete. Good list along with 34 list along with 34.
My lord, one more item is there, my lord. Item 38.
Item 38.
That is for settlement of Notun Bazar, my lord.
Item 38, Mr. T. Chakraborty, learned counsel for the petitioner. Notun Bazar Market. Then petitioner was second highest bidder, having quoted 13,17,000, and respondent number 7 was the 16th highest bidder, having quoted 8,36,236. Impugn order date hall 3/9/2022.
Here, my lord, the impugned copy is not annexed because that has not been provided, my lord. I have made a specific
Ms.
statement.
M. Burman for respond numbers 1, 2, and 3. Mr. B.D. Das, assisted by Ms. R. Deka for 4 and 5. 4, 5, and 6. 7 and 8 notice by registered post.
My lord. I may be permitted to take Dusty in respect of 34 and
You will
30.
come. Once the order is stayed, you don't have to take Dusty. You will serve Dusty notice.
Item number 35, I think respondent notice has to go to respondent number 5.
Yes, all right, but we will take the notice.
No, order is not there.
Notice private respondent of here, isn't it?
But I'll take steps for 35.
My lord, oil has come to Bazaar, my lord.
Achha, item 35, what? Ms. M. Burman for 1, 2, and 6. Mr. B.D. Das, learned senior counsel, assisted by Ms. R. Deka for respond numbers 3 and 4.
5, I will take steps.
Notice to respond number 5 by registered post to ready. 35. All right, so.
All right, my lord.
Yes.